Okay. If people don't identify themselves, I can't just let everybody in. I got another one with just an iPhone here. I got this one and this one. I don't know who this is. Well, let's see if they show up. If not, okay. Go ahead.
To me.
Ready to go? Everything's running?
Yep. Both are running, yes.
Okay. Yep. YouTube's just starting up here. Okay, good. Good evening, ladies and gentlemen. Welcome to a regularly scheduled meeting of the Zoning Commission of the City of Danbury, August 9th, 2022. Let the record show we will begin at 7:35 with a roll call. Commissioner Coelho.
Here.
Commissioner David.
Here.
Commissioner Fay.
Here.
Commissioner Hawley.
Here.
Commissioner Hylinski.
Here.
Commissioner Jowdy.
I'm here.
Commissioner Malillo.
Here.
Commissioner Rea.
Here.
Commissioner Bennett. I don't see or hear. We will mark him absent. Commissioner Duran. I don't see or hear. Absent. Commissioner Mahia.
Here.
She is here. And I am Chairman Haddad. 1, 2, 3, 4, 5, 6, 7, 8, 9. We have 9 of the regular members and we have 1 alternate. The next regular meeting is scheduled for August 23rd, 2022. If we can, please stand for, and everyone who has their flags, hold them up for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you very much.
There's no room. Just move myself.
Okay. During the meeting, if everyone could just mute their mics, commission members know when to turn them off and on. Mandatory virtual meeting instructions. Let me read them out. This meeting of the Danbury Zoning Commission is being held on Zoom as a virtual meeting. Even though this meeting is a virtual meeting, members of the public and interested parties continue to have the opportunity to participate in the meeting in a couple of different ways. You can participate via Zoom and see the audio and video, or you can call in by phone and participate via audio only. Please be aware that we may have to mute your microphone or telephone to avoid an echo or some other background noise. This is also being streamed live via YouTube. Instructions on how to participate in the meeting appear on the City of Danbury website, and all of the documents and materials that apply to the matters to be discussed during this meeting, including the agenda, are also available on the City of Danbury website. As always, if you have any questions, please contact the City of Danbury Planning and Zoning Department. As a reminder, the entire meeting will be posted on and can be seen on the City of Danbury website. We will follow the posted agenda as per standard practice. If prior to the meeting, any questions or comments on agenda items were submitted via email to Sharon Calitro, those comments will be read during the appropriate portion of the meeting. Finally, please remember that technology glitches sometimes do occur. Please be patient if that happens. Also, I see a lot of new faces, and we have 3 public hearings tonight. So when I said we will follow the posted agenda, basically this meeting will be run exactly as if it was in person, but sometimes a little bit slower. I wait to see hands or hear voices when people want to speak. Regarding the legal notice, this is the legal notice for the entire meeting as opposed to by petition. Legal notice is hereby given that the Zoning Commission of the City of Danbury will hold public hearings commencing at 7:30 p.m. on Tuesday, August 9th, 2022, in a web-based meeting hosted on Zoom to consider the following matters. Number 1, petition of Maria Lima Takuri and Isabel Lima to amend section 3F2D1A of the zoning regulations, in parentheses, reduced distance requirement between package stores from 2,000 feet to 1,000 feet. Number 2, petition of 3775 LLC and Robert Morsi, 1, 3, and unnumbered lot Pembroke Road, in parentheses G08029, G08030, and G08098 for a change of zone from RA40 to RMF10. Number 3, petition of 40-44 MPR LLC, property owner Robert Campisi for a special permit for cafe liquor license for Revolution, 40 Mill Plain Road, E15110 in the CA80 zone. Copies of these applications are on file in the town clerk and planning and zoning offices for public inspection. Parties in interest and citizens shall have an opportunity to be heard at this time. Agenda to be posted will include instructions on how to access the Zoom meeting and application materials and view the meeting in real time on YouTube. Theodore J. Hedda, Jr. Chairman, posted on the city website and town clerk's office on July 26, 2022, published in the News Times on July 29th and August 5th, 2022. Purchase order 2023-241. The agenda was posted in the town clerk's office on August 4th, 2022 at 4:36 p.m. Commission members, everyone received the July 26th minutes. Hopefully we all had a chance to read them. I'd entertain a motion to accept those minutes. Do I hear or see a motion from anyone to accept the minutes of the July 26th meeting?
Moved.
Thank you. Commissioner Member Fay makes a motion to accept the minutes. Is there a second?
Second.
Second by Commissioner Coelho. Any discussion? Not hearing any discussion. A yes is yes, a no is no. All those in favor signify by saying aye.
Aye.
All those
Aye.
opposed? Thank you. That is the acceptance of the minutes are unanimous. I'd like to, if I can, see if have a discussion with the commission in the interest of saving the taxpayers in the city of Danbury legal fees. I'd like to see if we can get a motion, or what's your pleasure, to move the old business up now. Old business for discussion and possible action on the petition of Sharon B. Cletro to go first this evening before the 3 public hearings. Commission members, any thoughts on that? We have Corporation Counsel, Attorney Edwards and Attorney Casagrande present. If they can go first and out, it would be less of an expense to the city of Danbury.
Mr. Chairman,
Commissioner Melillo.
yes, I would like to, I'm interested in knowing whether or not anybody may have any intentions or motions prepared and wanted to take action on this tonight. If no one was ready to take action on this tonight, then I would have no problem with us making a motion to table this item. However, I feel kind of funny moving a petition of the city of Danbury to the first item of business prior to any posted public hearings without any knowledge as to how long any discussion on that motion would take.
So you're looking to see if there's anyone here that basically right out of the box wants to express the possibility that they're not ready for this evening and they'd be looking to take another couple weeks to review materials. By the way, Commissioner Melillo, I'm told that everyone here has listened to all the tapes, has watched the video, so everyone here is qualified, including our alternate members. So we're good to go in that respect. So getting back to what Commissioner Melillo expressed, if there's someone here right out of the box that doesn't feel like they're going to be making a move on this evening and would wish to table it, let them express that now, and then that can at least give us the direction on where we're going on that. Commission members?
I'm good.
Who is that?
David, I'm good.
Okay.
I'm
Anyone
ready.
else? Got it. Anyone else have any comments?
Mr. Chairman?
Yes, Attorney Casagrande.
Yeah, if I may, I'm sorry to interrupt. I just wanted to add one thing, and I very much appreciate the commission's indulgence on this. I'm dealing with a personal family medical situation that's ongoing, and it is entirely possible that I may be getting a phone call from the hospital or the doctor during this meeting, in which case I would have to leave the meeting. And so any consideration you could give to deciding, if you're gonna move to table it, I guess you don't have to actually do that now. You can wait till the hearings are over, but it would be, I hate to have you go through all the the hearings and then I have to leave, because of this potential emergency I'm dealing with.
I follow. Thank you. I'm sorry for that. And also thank you for sharing that with us. Commissioner Malolo, let's bounce back to you. What are your thoughts on this?
Well, I guess my first question is, I don't know if anybody, if somebody has a motion prepared and ready, then we can entertain that for discussion. I understand and I sympathize with Attorney Casagrande. At the same time, I hate to I have to question, we have 3 public hearings. We have members of the public who've logged in at 7:30 for those public hearings. And I just question whether or not it's fair. Again, I don't know. I mean, if it's something that takes 5 minutes, it's not a big deal, but sometimes they can take 15 or 30. And I just want to be respectful to those members of the public who logged in for a public hearing.
I understand. I'm sympathetic on both sides, but then again, I'm going to go back to the original question. Is there a commission member here that wants to make a motion to go out of order and move the old business of petition of Sharon B. Calitro out of order and move it to the forefront at this time before the first public hearing is heard? Is there any commission member who would like to make that motion?
I'll make the motion.
I'll second.
There's a motion made by Commissioner David to do so, second by Commissioner Hawley. Any discussion? A yes is yes, a no is no. A yes would be to move the petition old business of Sharon B. Calitro out of order to right now, prior to hearing any public hearings. Let me take a roll call on that. Commissioner David,
Yes.
Commissioner Hawley,
Yes.
Commissioner Coelho,
Yes.
Commissioner Fay,
Yes.
Commissioner Hylinski,
Yes.
Commissioner Malillo,
Yes.
Commissioner Rea,
Yes.
Commissioner Jowdy,
Yes.
and I will vote yes. So we will move it to right now. So let me read into this record. Under old business for discussion of possible action this evening is a petition of Sharon B. Calitro, Planning Director, to amend Section 2B, 3C4, 5A, 2B, 5A5, 5B, 2B, 5B5, 6A, 2B, 6B, 2B, 8C, 4C, 10J, 11B2, 11B3 of the zoning regulations, in parentheses, amendment to clarify definitions of cannabis establishments, allow and regulate specific adult use cannabis establishments in specified zoning districts, establish a parking requirement, and prohibit issuance of variances for said cannabis uses. The public hearing was closed on July 26, 2022. So 2 things I'll mention. Number 1, we do have time since it was just closed on July 26th, so we don't have to take action for this evening. However, if everybody's ready, that we can. And additionally, since we did vote on a moratorium, we're not under the gun as it relates to that. Let me throw it out there. If there anyone that has any comments or wants to make a motion for purposes of discussion, either way, do so now. I'll look for hands or I'll look for here for voices.
Chairman, I move to approve this.
Commissioner David, go ahead, please.
Yeah, I make a motion to approve this petition based on this control. This will be in the best interest of the city of Danbury for the health and welfare.
Commissioner members, Commissioner David has made a motion to approve this petition with a reason stated. Is there a second to that? I'm sorry, are there any other reasons? Commissioner David, you good with that? You're all set?
I'm good with it, yeah.
Good with it. Is there a second, Commission members?
I'll second.
There's a second by Commissioner Hawley. So we have a motion to approve with a reason and a second. So now we'll put it out for discussion. Commission members, who wants to start discussion on this matter? Anyone have any comments on this?
Your hat out.
Commissioner Malillo, and then I see Commissioner Coelho can go next after that. Commissioner Malillo, go ahead.
Okay, I want to just put on the record, because I intend to vote no on this petition. I want to give a reason why I'm voting no. I've given it ample thought. despite what Corporation Counsel said, they can't conclusively tell us that this is a legal action. They are telling us that this is still illegal under the federal guidelines. What they're telling me is, you know what, yes, it's illegal, but don't worry, you're not going to get caught, or don't worry, you're not going to get in trouble. That's like telling my daughter, you know what, go ahead and sneak the candy when I'm not home, because I'm not going to know and you're not going to get in trouble. Or go ahead and steal from that store because no one's looking and you're going to get in trouble. And so I myself do not feel comfortable approving something that is illegal. So for that matter, I am going to vote no.
Thank you very much, Commission members. Anything of Commissioner Malillo right now?
Yeah, I have a comment. I have a comment.
You have a comment as it relates to Commissioner Malillo's statements?
Yes, I do. Yes.
Sure, go ahead.
Yes.
Commissioner David, go ahead.
I made many references to approving this based on safety of the people that are going to consume this product. I don't consume it, but people are going to do it, whether you go to the candy store or let them or not. Okay, and if we approve this based on the petition, the guidelines, it's going to be safer because people are going to do this whether you approve it or not.
Thank you. Before I go to Commissioner Coelho, I'm sorry to do this, but I see a box that says Deborah and Sean Kennedy. If you would turn your microphone off because I'm getting feedback from you there. Thank you very much. Appreciate it so much. Commissioner Coelho, go ahead, please.
Thank you. I had a question to make sure I understood it, if you would indulge me, and I'm not sure if this goes to Corporation Counsel or who might be able to answer it, but my understanding is in the event that there is a no vote tonight, just to make sure I understand this, people in the city of Danbury will still be able to order it via mail, have it delivered, or order it however over the phone, still have it be delivered to their residents in the city of Danbury, and still use it in the city of Danbury as if the zoning commission allowed establishments here. Is that correct?
Attorney Casagrande, please. Attorney Casagrande, we can't hear you.
You
No.
hear me now?
Yep, now we got you. Thank you.
Through the chair, the answer is yes.
Okay, just wanted to make sure.
Thank you. Commissioner Fay, please go.
Thank you, Mr. Chairman. In response to Commissioner Malillo's comments, I feel as though our purview on the zoning commission is not whether we legislate whether it should be legal. In the state of Connecticut, somebody has already made that determination on our behalf. The zoning commission simply decides where it will go, whether it will go within our city. And I think kind of aligned with what Commissioner Coelho just stated, it's sort of akin to the dry towns, whether that's Wilton or some of the other towns that used to be dry. I mean, obviously you can go next door to the liquor store and buy a bottle of wine or something like that, even though you couldn't buy it within the town limits of Wilton. People, I think we all know, are still drinking within the town of Wilton, despite the fact that it may be a dry town. And I just think that's beyond our purview to consider whether federal agencies are still going to prosecute it. I mean, there's a huge dichotomy in the law, and regardless of whether we are, as a commission, morally opposed or condone its use, I believe that's beyond our purview on the zoning commission. And I know that in our discussions over the past few weeks, we've gotten pretty far afield as to whether someone from New York could come over the border and buy it. And nobody really got into the privileges and immunities clauses and what is constitutional. But obviously, you do not need to be a Connecticut resident to purchase that. And you don't need to be a Danbury resident to go into Springfield resident to go into Massachusetts and buy it and bring it back to us. Or similarly, somebody from Bethel can come into Danbury, just as people from Danbury have gone to the Bethel, whatever it was, DMB Wellness before it came to Danbury. And I just don't think that would be a valid reason for our commission to vote no to Sharon Calicho's petition.
Thank you, Commissioner Fay. Commission members, any questions of Commissioner Fay's comments or want to talk to her about those comments? Any other commission members want to speak on this matter? Any other commission members have any thoughts on this? Okay. My only thought at this time is, do we have enough valid reasons to go along with that motion to approve? Ms. Calitro, any comment on that?
Sure. Thank you, Mr. Chairman. Yeah, I mean, if Commissioner David would be willing to amend, I mean, again, it was the amendments were approved by the Planning Commission. You have their report on file. And as was stated and as part of the record, and I think I've stated it numerous times about the restrictions on the establishments that would be allowed are pretty significant and were carefully thought out and considered. So it's highly regulated at the local level. And again, we're not opening the door. This is a very limited number of establishments to kind of see how it goes. So you could add those reasons as well. And then I'd also just like to add and it was also discussed on the record, the definition and the locational requirements and why they were included. And it wasn't anyone's intent to, have some absurd scenario considered that may have talked about, like a volleyball court in somebody's backyard. And that being a public recreation area. I think we're all understand what public recreation area means. It could be a park, it could be a golf course, it could be a public trail, it could be a river walk that has some equipment associated with it, but not a park. So I just wanted to go back and be sure, and I think I said this all on the record as well. And as to the bus stops, that information is available online. So that all goes to the legislative intent was to be as clear as possible, to follow what we was intended under the state law. And I think if Commissioner David would allow an amendment that, again, these are highly regulated and the staff and we've considered very well thought out regulations that are protective of the public health, welfare, and safety of the citizens of Danbury.
Thank you, Ms. Calitro. Attorney Casagrande, please.
I wish to consider amending his motion to have a specific finding as to the consistency of the petition with the plan of conservation and development. That's required for any action to change a zoning regulation. So when you adopt the resolution, protecting the record for any potential appeal, it's very helpful to have a collective statement of the reasoning of the commission. Director Calitro added a few other reasons that I think Commissioner David might wish to consider adding as a reason for his motion. I would also just ask him to add that the petition, if he believes so, that the petition is consistent with the plan of conservation development for the reasons stated in the staff report.
Thank you very much, Attorney Casagrande, Ms. Calitro. So I would ask Commissioner David if he would take the additional comments as further reasons to his motion, and ask if he does so, if Commissioner Hawley wishes to remain on as a second on that.
Okay. Hello?
Yes.
I'd like to be brief, but I would love to add all those things because I feel that with all the guidelines, clarifications, all these comments that Attorney Casagrande made and Sharon made, it makes this better, safer, and better controlled.
Thank you,
So I
Commissioner
amend
David.
it for those reasons.
Thank you, Commissioner David. Commissioner Hawley, you sticking with your second on that?
Yep, sticking with it.
Great. Commission members, any other discussion? Any other comments? So I'm going to take a roll call. A yes is to approve this petition with the reasons stated. A no is,
Mr. Chairman,
yes, Commissioner Melillo.
Ms. Solinsky had her hand up.
Oops, I didn't see that. Ms. Hylinski, so sorry. Go ahead.
Thank you, Mr. Chairman. I have
Thank you,
just
Commissioner Melillo.
a curiosity question. Since we last discussed this, has the status of cannabis in other towns, Connecticut towns, changed?
That's
Just
a
out
good
of
question.
curiosity.
So within the last 2 weeks, Ms. Calicio, are you aware of any changes of any of the reports that you sent us related to any of the surrounding towns?
And no, Mr. Chairman, I didn't follow up on everything that I submitted into the record
Ms.
to see if
Hylinski,
somebody acted within the last 2 weeks based
Mr.
on.
Chairman,
Commissioner, hold 1 second, Commissioner Melillo. Ms. Hylinski, Ms. Calicio is unaware of any changes from her report within the last 2 weeks or so.
Thank you.
Mr.
Thank
Chairman,
you.
a point
Commissioner
of order.
Melillo.
Just to the point of order, we actually wouldn't be able to take any information for the last 2 weeks because the public hearing has been closed. However, because Ms. Hylinski did miss the last meeting, I think it is fair to let her know that as of the last public hearing, there was no status change. But in the last 2 weeks, we wouldn't be able to consider that.
Right.
Thank you. I'm sorry I didn't see your hand, Ms. Hylinski. So I'm going to look again for any commissioner's hands. Commissioner Hawley, did you have your hand raised?
Yep. Can we just review who's eligible to vote on this?
All 9. Actually, all 9 are eligible, and if we needed our alternate, Ms. Mahia is also available. So everyone's available. A double check on that, Ms. Reed, that's correct? Yes, it is. Thank you. So a yes is yes, a no is no, unless there's anything further. I'm double checking. I don't see or hear. Mr. David,
Yes.
Mr. Hawley,
Yes.
Mr. Coelho,
Yes.
Ms. Fay,
Yes.
Ms. Hylinski,
No.
Mr. Jowdy,
Yes.
Mr. Melillo,
No.
Mr. Rhea.
Yes.
1, 2, 3, 4, 5, 6, 7, and I will vote no. 1, 2, 3, 4, 5, 6 to 3, it is approved. Before we push that away and go next, let me just compliment the staff. That was a terrific report. I don't think there was anything that was missed on it. I know that there was an awful lot of work that went into it, and thank you again for that efficient, complete report. So now let
Thank
us
you,
go
Mr.
to,
Chairman.
yes, you're very welcome, very deserved. Let's go now to page 1. Go from page 2 to page 1. First public hearing this evening is a petition of Maria Lima Takuri and Isabel Lima to amend section 3F 2D1A of the zoning regulations, reduce distance requirements between package stores from 2,000 feet to 1,000 feet. Let me read the Planning Commission recommendation on July 14th, 2022 to Theodore J. Haddad, Jr., Chairman of Zoning Commission, Ronald Lee Finaldi, Chairman, Planning Commission. 8-3A referral petition of Maria Lima Takuri and Isabel Lima to amend section 3F2D1A of the zoning regulations, reduce distance requirement between package stores from 2,000 feet to 1,000 feet. At the web-based Zoom meeting held on July 6, 2022, the City of Danbury Planning Commission voted to give the above referenced petition a negative recommendation for the following reasons. This is not consistent with the Plan of Conservation Development. The same reasons expressed by the Zoning Commission in our 2004 denial of the same request are still relevant today. And since Danbury now has even more licenses available based on population growth, this amendment is not in the best interest of the city and does not protect the public health, welfare, and safety. The motion to give this a negative recommendation was made by Mr. Sylvain, seconded by Mrs. Hofstadter, and passed by voice vote with 4 ayes from Mr. Chiocchio, Mrs. Hofstadter, Mr. Sylvain, and Chairman Finaldi. Further, the 8-3B referral from the Western Connecticut Council of Governors, Government, let's see. It's the opinion of Westcott staff is that the proposals of local interest and with minimal intermunicipal impact. Therefore, it is not being forwarded to the adjacent municipalities, and the regional staff is making no comment. Ms. Calitro, would you like to discuss your staff report?
Sure, thank you.
Thank you.
So you're all in receipt of staff report dated June 30th, 2022, regarding the petition for Maria Lima Tukuri and Isabel Lima to amend section 3F 2D1A of the zoning regulations. And that regulation sets forth distance requirements between package stores in Danbury, and the petition seeks to reduce the distance requirements between package stores from 2,000 to 1,000 feet. And I just quoted from the reason, from the petition, the reason why they feel this petition should be granted. I'm not going to reread it for the record. It's part of it. So Maria Lima Tukuri does own property at 50 Division Street. That property is within 2,000 feet of a package store located at 2.5 Division Street. As mentioned to staff by Attorney Mizuko in a telephone conversation to us, questioning the distance requirements. She may also have be a contract purchaser for another property in the general vicinity of Division Street, which is also within 2,000 feet of that liquor store at 2.5 Division Street. When Ms. Corey also inquired about the distance requirement, she was informed by Sean Harity, who's our zoning enforcement officer, that she would have to have a surveyor measure the distance in order to meet that requirement, which would enable her to apply for that use. So apparently, whatever property she was inquiring about, whether it was the one at 50 Division Street or an additional, the other property, it didn't meet that requirement. And so hence the petition to try to amend the regulations. And as I indicated, the distance requirements for package stores was established in Danbury over half a century ago. And in fact, 18 years ago, Attorney Mizuko, representing another petitioner, sought to amend the regs to delete the same requirement, as well as the requirement to schools and churches and charitable institutions and libraries, that petition was later amended to retain the distance from schools and churches, but to reduce the distance requirement. That petition was denied by the zoning commission, and the petitioner filed an appeal. And in that case, Attorney Mizuko claimed, among other allegations, that the zoning commission, in its denial, relied on reasons not rationally related to a legitimate purpose of zoning and undervalued statutory and regulatory controls that already limit the number of and location of package stores. And so we went back, we looked at the reasons why the zoning commission denied that in 2004 and felt they were still relevant today. Number one, the commission indicated at that point, they found that the existing separation requirement had served the city well by preventing an undue concentration of package stores in close proximity to one another, and has resulted in the convenient distribution of package stores throughout the city. Number two, notwithstanding restrictions of the state of Connecticut, the existing separation limits the number of properties engaged in liquor sales within the zoning districts where otherwise permitted. The elimination of the separation district, again, at that time, he was proposing to eliminate it, would result in the location or relocation of additional package stores in the downtown area or near residential neighborhoods in the urban core, resulting in an environment that is not conducive to the health, safety, and welfare of the resident population. And finally, regulation of the sale of alcohol is a legitimate exercise of police power. The commission's decision in that case was upheld at the Superior Court level, and a subsequent appeal was filed at the appellate court. In that decision was the Stu Leonard's LLC versus the Zoning Commission in the city of Danbury. And that appeal was dismissed, So licenses to operate package stores, as I indicated, are issued by the state of Connecticut pursuant to local zoning approval. And they're based on the number of package stores allowed is based on the census and our 2020 census numbers. now allow a total of 34 licenses. There are 4 licenses now available in the city of Danbury. We checked the website. Anybody can go on, find out where they are. Package stores, which are subject to special permit approval, are allowed in the CG20 zone, the CA80 zone, the CN5 zone, the CN20 zone, the CBD zone, the RR10 zone, and the CL10 zoning districts. This amendment will affect all the districts where package stores are allowed. We have continued concerns related to the effect this amendment would have on the downtown and in other areas of the city. And we support maintaining the current 2,000-foot distance requirement, as it will continue to help ensure neighborhoods remain protected against the undue concentration of package stores. And I provided you some quotes from Judge Schulman in his STLJ decision, which he said protection of these neighborhoods, which were neighborhood commercial zones, many of which are in close proximity to the older residential neighborhoods, is a legitimate concern of the commission. That's what he said back then. He also noted in STLJ that the fact that package stores may be adequately dispersed at the current time does not mean they will not relocate and concentrate in downtown areas and neighborhoods in the future if they are no longer subject to a distance requirement, or a less distance requirement is in the present case. And he also said, because it is not clear that Danbury has reached the maximum number of liquor stores allowed under state law, elimination of the distance requirement may result in an immediate increase in the number of package stores in the town. The commission could reasonably seek to avoid this result. So those were quotes from that case. There is no substantive justification to amend those longstanding regulations promulgated to protect the proliferation or cluster of package stores in locations in the city, and how other municipalities opt to regulate these package stores or not do it is really irrelevant to Danbury. The existing regulation continues to serve a public purpose for our growing Danbury community. In terms of the plan of conservation and development, it's questionable as to whether the commissions could find that reducing the distance requirement, which is what is proposed from 2,000 to 1,000, when more licenses are now available, is consistent with the vision statement in the plan of conservation and development and the reiterated concerns in that plan about balancing growth, promoting the downtown and the west side, and protecting our residential neighborhoods. So in conclusions, for many of the same reasons expressed by the Zoning Commission in 2004, when an applicant sought to delete the distance requirement, and since Danbury now has more licenses than they had due to our population growth, it is our staff's position that the amendment is not in the best interest of the city and does not protect the public health, welfare, and safety.
Thank you very much, Ms. Calitro. Let's see. Anyone wishing to speak in favor of this petition? Attorney Mizuko.
Yes, Mr. Chairman.
Good evening.
Thank you very much for allowing me to comment this evening. I do have a PowerPoint presentation with some documents that summarize our position. With the chair's permission, may I share my screen?
Absolutely. And while you're doing that, let me thank you and your client and the other 2 petitions for allowing us to take that other petition ahead of you. Thank you.
Not a problem at all. Thank you very much.
So go ahead and do what you have to do on the screen share. We're all set.
Okay, thank you very much for that. So yes, I'm here on behalf of this petition to amend the zoning regulations. And I want to be clear on what exactly the request is. And here's the proposed amendment. It's to reduce from 2,000 to 1,000 feet the distance required between package stores in Danbury. And of course, when I say in Danbury, we're really talking about certain commercial zones. It's not allowed in residential, they're not allowed in residential zones and so forth. The significance of that is that, with all due respect to the thorough presentation of the planning department, that was all about a regulation that proposed to eliminate the distance requirement between package stores. What I'm talking about tonight is merely a reduction of it from 2,000 to 1,000 feet. And let me elaborate on why that is appropriate here. Orient my screen a little better here. So Danbury has distance requirements in several contexts in the zoning regulations. Let's talk about service stations first. They have to be located 500 feet from nurseries, kindergartens, schools, hospitals, churches, etc. But there's no requirement that they have to be separated from one another. In fact, this commission eliminated the distance requirement for service stations back in the early 80s. So without any separation required between them, service stations can be clustered and have combined effects on a neighborhood. And you know how service stations do tend to cluster, so that whatever effect they may be deemed to have on a given neighborhood, the combination of a cluster of them accentuates those effects, whatever they may be. And that's allowed. The regulations allow for that. So another lesser known regulation, it has to do with electric power plants. They have to be 500 feet from any residential district, but there's no separation between power plants required. So if they were to be clustered, they could have a combined effect on neighboring properties. Now, this one's really interesting. The processing of earth materials. There, they have to be they have to be separated from certain uses, but they can still be clustered and have combined effects on neighboring properties. The one that is most analogous, one could argue, is adult uses, where section 5A says that they have to be 1,000 feet from any other adult business use and 500 feet from any residential zone or a church, place of worship, school, play area, and so forth. And that leads us to package stores, which again require 2,000 feet. It's more than any other use in the city has to be separated, except possibly for certain cannabis facilities, which happened 5 minutes ago. But to be consistent, and I know the planning department likes to have consistency and integrity in the regulations, and a comprehensive plan of development, of course, requires your regulations to fit together in some logical, common sense way. So you have a number of uses that have no distance separation requirement at all. You get to adult uses where they have to be separated by 1,000 feet, and package stores stand alone in being separated by 2,000 feet. So, so if the city doesn't regulate the clustering of certain uses and allows and regulates adult uses to be 1,000 feet apart, it's really inconsistent to have package stores 2,000 feet apart. So let's look at the property. Well, here's a chart that kind of illustrates that. And you can see where package stores is an outlier on the right. And the proposal is to bring them consistent with other separated uses. But the property in question, and of course there's always a property in question on a regulation change. My clients own property on Division Street, close to the base of Park Avenue, the subject property there. The closest property, the package store, is about 1,300 feet away, where you have to go out to West Street, proceed west, and it's in that little shopping center with the Chinese food restaurant and so forth by the railroad tracks. Or you go in the other direction, which is over in essentially Worcester Square, that concentration of stores there and near the Sesame Seed restaurant. There's, if these were adult uses, they'd be perfectly allowable in those 3 locations. But because they're liquor stores, they're treated differently. And of course, there's another package store even farther away, but that one would be beyond the 2,000 feet. So to circle back to this proposed regulation, it would give flexibility to people who want to open a package store in Danbury. And if you look at the 2,000 foot separating distance for package stores, that means that they have to be in the center of about 289 acres of property with respect to other package stores. And if you lump in the separation that they have to have from churches, schools, place of worship, there really aren't many opportunities in the city of Danbury. So it does give a little bit of flexibility to people who want to enter that entirely legitimate business. As someone commented during the last public hearing, the legislature has decided that the sale of cannabis products is a legitimate activity in the state of Connecticut, subject to regulation at the state and local level. Similarly, package stores are a legitimate business subject to regulation at the state and local level. And again, it would promote the integrity and consistency of the regulations by bringing bringing the regulation for liquor stores into a greater consistency with what's already on your books. So that is my presentation. I appreciate your attentiveness to it. And if there are any questions, I'd be delighted to answer them.
Thank you, Attorney Mizuko. Commission members, are there any questions of Attorney Mizuko at this time? Looking for hands or voices. I see Commissioner Malillo, hand raised. Go ahead, please.
Yeah, Commissioner sorry, Attorney Mizuko. Just curious. Thank you for the map and for pointing out the location of the property that raised this question. Because I can't help but just think I'm familiar. I can't necessarily. I think I know where in the vicinity you're talking. I know definitely in the vicinity. I think I might actually be able to picture the actual property, but I definitely am within 2 properties of it because it's right over by U-Haul. And so it seems to me as though that property is kind of like smack dab in the middle of the two closest package stores. It's also a very tight neighborhood. Roughly about how long would it take to walk from that property location? Just let's say just down to the Division Street Square. Any idea roughly how long of a walk that would be?
From the property to Worcester Square, did you say?
Yeah, like down where, right down in that little. I'm thinking that's the closest.
Well, it's probably about a third of a mile, so probably 10, 12 minutes at a brisk rate. And of course, you're leading to a very good point that the specific location of any package store is subject to the further approval of this commission under the special permit process, where if a particular location seemed unsuitable, notwithstanding its separation from another package store, you could still deny it.
Right, which we could, I know, and however, if it was within the legal foot requirements, I think we would be a little bit hard pressed saying, well, you know what, this is a little bit too close to another package store. I think that we may not withstand that one as an appeal, but really, I was just wondering as to whether or not it could be considered it's obviously gonna be seconds in a car, but in a reasonable walking distance, how difficult that would be.
Thank you.
Excuse me, Mr. Chairman.
Hold on one second, Commissioner David. Are you all set, Commissioner Malillo?
Yeah.
Yes, thank you. Commissioner David, go ahead, please.
I just want to give you a little piece of my trivia here. I play a lot of golf, and I play 300. Average hole is about 330 yards. It takes 3 minutes to walk down 330 yards. which is 1,000 feet. Okay, there you go.
Thank you.
Close.
Close. Thank you. Commissioner Jowdy.
A question to Attorney Warren Mizuko. As per Sharon's statement, she said there's 34 licenses here in Danbury at this point and 4 available. Your petition is wanting to change it from 2,000 to 1,000. So that means, I'm asking the question, does that mean that the 4 licenses that are available, not only those, but any license that come up and any licenses that close, it's gonna do the same for the whole town? We're looking for a town change of 2,000 feet away to 1,000 feet.
Yes, Commissioner Jowdy, it would change it throughout the town.
Okay, thank you.
So Commissioner Jowdy, are you also basically saying that, or were you asking that anybody, if approved, anybody existing can actually relocate to another location that would be within 1,000 from each other, not just the 4 new licenses? You're of that understanding, correct?
I wasn't thinking of that, but that's a good point. If Sharon or anybody else wants to comment on this.
Well, that's what it would be. Anybody
Yeah.
can relocate their existing business. So it's not just if we change this from 2,000 to 1,000, that it applies to the 4 that are outstanding or any that may grow in the future based on population. It means that anybody that's sitting out there that has a license can pick up and move around and like a chessboard. Is that correct, Ms. Calitro?
That's correct.
It makes sense. Thank you.
Commission members, anything else? Don't shout if I don't see your hand. I don't see anything from any of the commission members. So I will now ask if there's anyone else wishing to speak in favor of this petition. Oh, I see a hand. Attorney Marcus wishing to speak in favor of this petition. Go ahead, sir.
Thank you, Mr. Chairman, members of the commission. Attorney Neil Marcus, Commonwealth PC 158 Deer Hill Avenue, Danbury. And I need to speak in favor of this because, quite honestly, the 2,000-foot separation rule for package stores is one of the most arbitrary zoning rules you could ever come up with. So I recognize in Sharon's Calitro's staff report, the history goes back over 50 years. I bet you, from my memory, it goes back over 70 years. And I would defy anybody who's going to consider this to tell me why it exists in the first place. Why in Danbury, not in a lot of other towns in the state of Connecticut, do package stores need to be 2,000 feet apart? And the answer to that I'll also give you is White Street. Following the repeal of prohibition in the 20s and the early 30s, there was a absolute proliferation of bars and package stores on White Street. Some of them are still there, but a lot of them are gone. It's part of urban renewal. But there was a concern that you were creating a vice district, a red light district, because of the bars and the package stores. So a zoning regulation was brought in and 2,000 feet was chosen. Now, I would also defy anybody on this commission or participating in this application to tell me why 2,000 feet? Why wasn't it 2,500 feet? Why wasn't it 3,000 feet? Why wasn't it 1,000 feet? And the answer is it was an arbitrary number that has absolutely no relationship to public health and safety. There are no studies that indicate that towns that have package stores 1,000 feet apart or 750 feet apart have a unhealthier condition. Now, if you think about it logically, on Federal Road, you have a concentration of automobile dealerships, and people go to an area to buy automobiles. Think if we had a concentration of package stores located where the automobile dealers are. So you had, 8 different package stores on Federal Road. And then look at the staff report which says that would create an unhealthy condition. It would be unhealthy and not in the public interest. And I say, why? I mean, why, if I want to go buy a bottle of wine or a 6-pack of beer, couldn't I drive to Federal Road and walk into any one of these theoretical 8 package stores? What's the difference? Why would I have to go to one that's 2,000 feet apart? On a personal level, I represent a large shopping center on Sugar Hollow Road. And we were approached a number of years ago by a very high-end wine store. And of course, we have a Whole Foods market on the site, and that attracts people who are looking for high-end foods. So it was a perfect location. And it broke my heart when I had to tell the prospective tenant that we are within 1,700 feet of the now Caroluzzi's package store. It wasn't at that time, but down on Sugar Hollow Road next to the Porsche Audi dealership. So we're 300 feet short of having a really high-end wine store. Now, again, I am personally not a very big user of alcohol, wine, or beer, but when I do have it, I enjoy buying a really quality bottle of wine or a high-end bourbon. And I love going to a package store where I go to a package store kind of like a library. I read all the labels and look at all the various artwork on the bottles. But the fact that we are slaves or bound to a 2,000-foot rule without understanding the origin of the rule and understanding why it exists really irks me. And to this day, I'm sorry that we had to turn down a retailer who I think would have added to the quality of our community for people who want to buy high-end wine. Liquor stores today don't have the connotation that they did 50 or 70 years ago when you might have 3 liquor stores right next to each other. If you look at the stores that exist today, and I'll cite the new Caroluzzi's package store in Bethel on Greenwood Avenue. It's really a top quality store, and it doesn't connotate any public health or safety problems. I'm still trying to deal with that concept of how liquor stores that are 2,000 feet apart provide better public health or safety than those that are 1,000 feet apart. So I didn't come to this meeting tonight to speak in favor of Attorney Mizuko's petition. I saw it on the agenda. I read the staff report and I listened to the presentation, but I'm compelled to say that his application makes sense, and that at this point there is no logical and certainly no zoning reason that I can think of to adhere to a 2,000-foot separation. And I think Ward has gone through where we have separating distances from churches and schools, and those are based upon old traditions as well. But for package stores, I mean, it doesn't make any sense. So I would encourage you to vote in favor of this petition, because I think it opens up the opportunity for some higher class retailers to locate in the city of Danbury. And at the end of the day, you're still limited to 34 licenses. It's not going to become a huge problem in any respect. So I thank you for listening to me, and I'd like you to give some real thought to where the number comes from and what the world would be if it were half that, if it were 1,000, because to me, nothing would change. Thank you.
Thank you, Attorney Marcus. Commission members, any questions of Attorney Marcus at this time? I don't see any. The next,
Hold on. You can't have a meeting of the zoning commission without a question from Mr. Melillo.
Commissioner Melillo, go ahead, please. Thank you.
I have to ask Attorney Marcus a question if he talks in front of us. I got to keep up tradition. Anyway, Attorney Marcus, I fully understand if you don't know the answer off the top of your head, but I think you might. And this popped into my head when you were talking, because you were talking about history and tradition, and I was thinking about the 2000. And in my head, the number 1,500 stood out for a second. Do you happen to remember? I know our old regs prior to the latest revision, had the distance along the street, and now we've done it in a straight line. But when it was along the street, do you remember, was that a 1,500-foot division?
I have to confess, I can't remember, but I will tell you that that was the number, and is the number in the town of Brookfield, 1,500. That's the number. And
Okay.
years ago, they used to measure it from the property line. So if you had a shopping center, for example, two shopping centers next to each other, then you couldn't have a package store in both of them because the property line was closer than 2,000 feet. Then we changed it to measure it across the street, and then we did it as a crow flies. But I don't recall in Danbury whether it was 15 to 2,000. I do know in Brookfield, it has been 1,500 for many years.
Yeah, 'cause
Again,
I do know,
an arbitrary number.
yeah, well, because I do remember, and I do know for Danbury, we do measure door to door and not property line to property line.
Yes.
And for some reason, I was thinking that the 2,000-foot, I was thinking we just increased it to 2,000 from 1,500 with that, as the crow flies, with that straight line to compensate for a radius, which would be about equivalent to the 1,500 as the road. But I wasn't sure. So thank you. I just wasn't sure if you happen to remember that off the top of your head.
I'm going to defer to Ward Mizuko, who might have that answer, because he was involved in this whole issue, as was cited, 14, 15 years ago on the same issue. He might know.
Attorney Mizuko, did you have a comment on Commissioner Melillo's question?
No, I'm afraid I don't know the answer
Thank
to
you.
that, but 1,500 does ring a bell. I think that may have been the correct number at the time. I can't be sure.
Anything else of Attorney Marcus at this time, commission members? Moving right along, I see Representative Ken Gucker. You have your hand raised. Thank you. You have the floor also. Go ahead.
Well, thank you, Chairman Haddad. I just wanted to voice my opinion in opposition to this. I did not come here for this particular piece, but I'm a little disturbed because as somebody who does talk to all the small businesses, which are the liquor stores in our area, and how they have been stretched to the limit to where they thought they wouldn't be open on Sundays, we changed it till Sundays. They thought that they were going to close at earlier hours, we extended their hours. And now as we go along to talk about changing this distance situation, it just adds more competition they can't afford to survive from. And the problem is folks, there's only a finite amount of individuals. So the more that you bring in, the harder and harder it is for these small businesses to survive. Whether it be they have to hire people to be there when nobody comes in to purchase anything from them, or they have to be open on days when nobody's coming in. And now we're talking about diluting the market. There is a point that, we need to start looking and protecting those small businesses. We need to start looking at what they've invested in. And many of these people have invested in their life savings into this position. So that being said, I have a real problem with changing the rules after the fact. I have a problem with adding more competition. I mean, usually competition's good, but when you've already got people look, I'm 2,000 feet from the queue, so I could walk there in 3 minutes. So should I have 2 liquor stores between here and the queue? I mean, there's no need for this. Okay, so there's no need to complicate the issue. There's no need to expand this issue. And I feel that by doing so, you are causing harm to the very folks who have been struggling through COVID, who have been struggling through the changing environment, and been struggling through the laws that sadly we have changed in Hartford before my time, obviously, of the Sundays and the longer hours to where they spend less and less time with their families, that now you're going to deplete more and more of their customer base. So I firmly am opposed to this petition. Again, you'll hear from me later on something else, but I just couldn't let this go by. Thank you. Thank you, Mr. Chair.
Representative Gucker, we were on the portion, I didn't realize until your last statement where you were going with this, but we were on the, all those in favor. So when I get to those opposed, I'm going to read you back, I'm going to read your name back in to go onto the record as opposition with your comments that you just read.
Yes, thank you very much.
and-
I'm getting used to having to work this computer again.
That's all right. Are you going to stay here for a few minutes or are you going to log off?
Oh, no, I'm going to be here until I get to
Okay.
the reason why I came here.
So I'll ask, when we get to opposition, I'll just ask if any commission members have any comments on what you just said. So we'll cover that. So we'll get back to you if we need to. Anyone else wishing to speak in favor of this petition? Anyone else wishing to speak in favor of the Attorney Mizuko, you have a comment?
Yep, Mr. Chair, I don't know if you want me to go now or wait till the opposition has ended, but I did want to respond to some of the comments that were.
Yeah, let's wait till the end on that.
Yes, sir.
Thank you. Please keep a note on that. Anyone else wishing to speak in favor of this petition? Anyone else wishing to speak in favor of this petition? Anyone else wishing to speak in favor of this petition? Let me check page 2, see if I have see any hands. I don't. Anyone wishing to speak in Ms. Calitro?
Oh, I didn't let you finish. Opposition.
Okay. Anyone wishing to speak in opposition to this petition? Ms. Calitro, I think you have a
Thank
couple.
you. Yeah, so I got a note from Councilman Rotello that he please ask that I relay this as part of the public hearing, that he objects to the reduction in the distance requirements for the same reasons he did in 2004 when they acted that are a part of the record. So.
Thank you. That's all you got on that? Thank you.
Yes, please tell him I object. That's what he said.
So we're on the those opposed portion. So now let me see if any commission members have any questions or comments of Representative Gucker at this time, based on what he said a couple minutes ago in opposition. Any comments or questions of Representative Gucker? Commissioner Malolo, go ahead.
Yeah, I just want to put, I'm going to form this as a question, but it's more for the purpose of a clarification, because when Mr. Gucker was talking about the changes made regarding the extension of package store hours and the sales on Sundays and all that, I just want to clarify, those were legislative decisions based out of Hartford, not based from the Zoning Commission, correct?
Yes, they were.
Thank you. I just wanted to.
And again, the reason why I brought them up is to show the additional hardships, whether it be from Hartford or whether it be from the local boards, of what they've been dealing with.
Yeah, no, I don't question your reason for putting. I think it's a valid point. I just wanted to have the clarity that that there have been some impositions imposed by Hartford on them, and and here we are their local entity as well, and we want to be mindful of our small business owners.
Well,
yes, thank you for that clarification. Thank you.
Actually, Commissioner Malillo, thank you for pointing that out. And that for the other commission members, who I think everybody's here long enough to know that there's a lot of things that Hartford does that when it comes to, for example, the cannabis, the liquor, the betting, the off-track betting, the lottery, a lot of things that Hartford does or changes that we're subject to and we have to live with over the years, that we take that into consideration. So while we're on that subject, while Danbury does have 30 package stores with 4 more to go, I believe the state of Connecticut at any time, if they choose to do so, and I don't know if it's on the horizon or not, but they could change the number of package stores based on population again. And it could even increase further. And we would take that into consideration on a petition, for example, for this evening. Anyone else wishing to speak in opposition to this petition? Anyone else? Is there a question of Commissioner Jowdy?
Yeah, it's not an opposition. It's just a statement. 34 package stores, we reduce it down to 1,000 feet. These package stores, like Commissioner Ted Haddad had said, I would think they can move around like chess, okay, checkers and this and that. So now these 34 are going to be clustered in. They're going to be moved around. There's going to be open spaces as opposed to being spread out, and it's not going to be conducive. It's not going to be convenient for everyone like we thought it would be. It would just it would make it, I think, very confusing.
Thank you, Commissioner Jody. Commissioner Helinski, did you have your hand raised also? Oh, okay. Anyone else wishing to speak in opposition to this petition? Anyone else wishing to speak in opposition to this petition? Anyone else wishing to speak in opposition to this petition? I am closing for now opposition to this petition. I'm going to go to Attorney Mizuko, who says he has some comments on some previous speakers. So Attorney Mizuko,
Yeah.
go ahead, please.
Thank you, Mr. Chairman. So some of the concerns you just heard about had to do with competition and protecting small business. If the proximity of businesses to one another was a problem, then all those automobile dealerships on Federal Road that Attorney Marcus mentioned would be failing, and they wouldn't be rushing to go over on Myrie Brook either. All those clothing stores in the mall would be going out of business. In fact, it's the concentration of businesses that often makes them more successful. It's why McDonald's and Burger King are on opposite sides of the corner. So add to that the fact that of all the considerations that are legitimate in zoning under Section 8-2 of the general statutes, competition and protecting small business is not listed anywhere. In fact, there are lots of cases saying that it's inappropriate for commissioners to make zoning decisions based on suppressing competition among businesses. So what we get back to is what Attorney Marcus said. There was a problem on White Street, probably in the 40s or 50s. That's been long since resolved. And the major argument in favor of perpetuating the arbitrary 2,000-foot distance requirement is that that's the way we've always done it. That's the way we've always done it. The worst justification for any policy at the federal, state, or local level. And if you consider that this commission, this very commission, about 40 years ago, eliminated the distance requirement for gas stations, between gas stations, that is. What the commission did then was very interesting. The commission actually did what Mr. Marcus suggested. They consulted other city agencies. They asked the police chief, are there more accidents around gas stations? They asked the fire chief, are there fire problems? One gas station catching fire and causing fire at another one? And they did that with city departments. And you know what they found? There weren't any problems. The fire chief was happy. The police chief was happy. And I forget who else they asked. It's a long time ago. But the point is that none of that's been done here. We're just going on a supposition that this is the way we've always done it. There could be problems. There could be a concentration. Oh my goodness, it could be dangerous. But is there any support for it? No. I would respectfully suggest that maybe the commission would want to keep the hearing open and actually ask the police chief, the fire chief, and so forth, whether they see any justification for opposing the very modest reduction of the distance requirement from 2,000 feet to 1,000 feet. This is entirely different than the application from 14 years ago that we heard all about tonight. That's not before you tonight. Tonight's application is just 2,000 to 1,000, not an outright elimination, although that's probably what should happen. So that my respectful suggestion would be to get some evidence and consider whether this application really does make sense, especially when you consider it in light of other uses which don't have to be separated, or if they are, it's at a distance that makes more logical consistency with other regulations on the books. Thank you for the opportunity to comment.
Thank you, Attorney Mizuko. Commissioner Melillo, question of Attorney Mizuko.
Yeah, thank you. Attorney Mizuko, quick question. You're talking about gas stations and when we eliminated, or back in the 80s, when the zoning commission eliminated the distance requirements of gas stations. At that time, did the state have a restriction as to the number of gas stations the city of Danbury was allowed to have?
Well, gas stations were licensed there was some state licensing, and there was the procedure under Title 14, I think it's maybe 14-52 or 54, where they had to be approved by, I think at that time, the Zoning Board of Appeals, if my memory serves me. But
Right,
was there an outright limit on the number? No.
Okay, yeah, because that sounds almost like a liquor, like a restaurant liquor license or something along those lines, where there's no limit, but there has to be approvals there. But and here we are talking about an instance with something where the state of Connecticut has put a limited number of restrictions. And so while I'm thinking, not from a competition standpoint, but if you took a large number of package stores and you clustered them together, would that have a negative impact on the equitable distribution of package stores within the geographic area of the city of Danbury?
I'm not sure I followed the question. What have an impact on the equitable distribution?
If you took, because the state of Connecticut has limited the number of package stores that the city of Danbury can have. If we took and we reduced the distance of it, and then there was a clustering of it, which could potentially happen, as was mentioned by a couple instances this evening, would that clustering of large numbers or a larger number of package stores in a smaller area, would that have a negative impact on the equitable distribution of package stores in the geographic area of the city of Danbury?
Well, I guess it depends on how you define equitable. From the standpoint of the consumer who'd like to buy his product, a high quality product, when and where he wants to, more package stores is clearly a benefit. That's why we have more clothing stores, more auto dealerships. Consumers want choice. From the equity of package store owners, we're talking about adding potentially a few package stores in a city where people already have an abundance of package stores is really not going to make a difference. And sort of like the marijuana, they're not confined to the city of Danbury. They can go to Brookfield, they can go to Bethel, they can go to Ridgefield. Plenty of liquor stores around. People want convenience. People want convenience. Why would we want to deny them convenience? If a store owner feels that he can serve the public and earn a living by being in a location that's just over 1,000 feet from another business, what concern is it of the commission, really?
I think with the idea of people wanting convenience makes sense. And I think that's one of the reasons why I was going to ask Ms. Calitro, but I'll go ahead and ask you. I believe traditionally, again, there's that word traditional, but traditionally in the city of Danbury, most package stores tend to be neighborhood package stores located in neighborhoods, and people stop by on their way home at their local package store because it is convenient and that is a convenience for them. And so therefore the ability of maybe having more local neighborhood package stores might abide by that aspect of it, but just the quantity of package stores with them being clustered together, I'm not sure if that would have that same impact. Do you have any thoughts in regards to the differentiation with the traditional neighborhood package store environment?
I don't think I can. All I can say is that I can't think of any other business where the number of them in the city is restricted. There can be as many doctors, lawyers, and accountants, as many clothing stores, car dealerships, shoe stores. If you want to open one, you can. The only one where everyone is interested in restricting the number is package stores. Doesn't make sense. It's just inconsistent with everything else that goes on in the city's economy. We're a city that's supposed to support business. You support business by allowing it, except in locations where it's truly a danger to something. Would you want a liquor store right next to the high school? Probably not. But short of a situation like that, is it really a problem for a liquor store to be only 1,000 feet from another one? I don't think so.
Okay, just as one more follow-up, I wasn't going to ask, but I wanted to ask this in light of the comment you just made. This particular petition, though, would have no impact on the fact that the number of package stores in the city of Danbury are restricted, just how close they can be to others, correct?
Yes, sir. Right.
Yeah.
You guys all set? Commission members, Anything else of Attorney Mizuko at this time? Commission members of Attorney Mizuko? I don't see her here. Any final comments, Attorney Mizuko? Ms. Calitro?
Yes,
Any-
Mr. Chairman.
Any closing comments?
No, I think our staff report's pretty straightforward.
Mr. Haddad, may I ask a question to staff?
Yes, absolutely. Commissioner Malolo, go ahead, please.
Okay, Ms. Calitro, I just wanted to ask, in relationship to the idea of the neighborhood package stores versus more of a commercial area package stores. Weren't we recently sued because we did have from a property location, the properties were closer than 1,500, were closer than the regulated distance, but door to door, it was farther away. So therefore, in a commercial zone, it's theoretically possible for package stores to be closer together property wise, while at the same time respecting an appropriate distance in neighborhoods. I'm thinking down a Mill Plain Road.
Yeah, I think that it was how it was measured, yeah. And then
Yeah.
we revised the regulations to not make it as complicated and just went door to door in a straight line versus how you walk and which side of the road you're on, because if you cross the street, get to the other side of the road, you've added footage, linear footage, so.
Yeah, because I remember part of that, part of the opposition with that in that public hearing was that the property location was close to an existing package store. However, the distance from door to door, as measured for door to door, was within the guidelines. So therefore, theoretically, even when you look in our regs, you can have package stores in property locations relatively close together, even though the distance is farther because they're located in a large scale commercial zone,
Right.
correct?
Right, yeah.
Thank you.
Thank you, Commissioner Malolo, Ms. Calitro. Commission members, anything else of Ms. Calitro? Okay, it's two things can happen. We make a motion to continue the public hearing, or we make a motion to close the public hearing. What's your pleasure? Commissioner Fay.
Chairman,
Oops, I'm sorry. I saw, do you have a question, Commissioner David? I saw Commissioner Fay's hand go up. Do you have a
no, I
question?
want to move to close the public hearing.
I'll second.
It's a motion to close the public hearing by Commissioner David, second by Commissioner Fay. Any discussion? I don't see any. I don't hear any. All those in favor of signify by saying aye.
Aye.
All those opposed? For the record, I did not see any opposition or hear any opposition. So this public hearing is closed. Thank you, everyone. Number two this evening, excuse me. Petition of 3775 LLC and Robert Morrissey, 1, 3, and an unnumbered lot on Pembroke Road, G08029, G08030, and G08098 for change of zone from RA 40 to RMF 10. So what I'm going to do is I'm going to read into the record here the Planning Commission recommendation, July 14, 2022, to Theodore J. Haddad Jr., Chairman of the Zoning Commission, from Arnold E. Finaldi Jr., Chairman, Planning Commission, 8-3A referral, petition of 3775 LLC and Robert Morrissey, 1, 3, and an unnumbered lot on Pembroke Road. At the web-based Zoom meeting held on July 6, 2022, the City of Danbury Planning Commission voted to give the above referenced petition a negative recommendation for the following reasons. Number one, this proposal is inconsistent with the Plan of Conservation Development. Number two, this request does not meet the criteria for a zone change to multifamily as specified in section 10I(3) of the zoning regulations. And this proposal is not in the best interest of the city and could result in detrimental impact on the health, safety, and welfare of the general public. The motion to give this a negative recommendation was made by Mr. Chioccio, seconded by Mrs. Hofstadter, and passed by a voice vote with 4 ayes from Mr. Chioccio, Mrs. Hofstadter, Mr. Sylvain, and Chairman Finaldi. Ms. Calitro, would you go over the staff report, please?
Sure, thank you, Mr. Chairman. So again, we received, you'll have a copy, and it's was posted with the agenda of the June 30th, 2022 staff report. We have received the petition. Oh, I'm sorry about this. I got the wrong I forgot to put the 5 on there, from 3733, oh, I have the number wrong. Sorry, 3775 LLC to rezone the 3 parcels on Pembroke Road from RE40 to RMF10. The reason the petitioner provides for the request, again, was quoted, I quoted from their petition. There are 3 subject parcels. They comprise 5.149 acres. They are requested to be rezoned per the petition, totals 5.39 acres. So the difference, or 0.241 acres, is the area within the right of way of Pembroke Road, although that area is not specifically noted on the proposed zoning map. There are 2 parcels immediately north of the subject properties that are zoned RA40, and slightly north and east is land zoned RA20, which, as you all may identify it, is the land of the Amber Colonnade. The lands to the south are zoned RA40, as is the property immediately west. Again, for identification purposes, that's the property of the Q Restaurant. Stetson Place residential property is zoned RMF10, and that is located to the north across the Pembroke Road, and with only approximately 70 feet of zoning district boundary in the center of Pembroke Road, adjacent to the 1 tax assessor lot G08030. And I provided a copy location map, so you could, with the dots on it, that indicated 3 parcels proposed to be rezoned. And you will see from the map, the RMF10 zone is the Stetson Place. The RA20, just to the north of the dots, is the Amber Root Colonnade. Tax assessor lot G08030 is 1.012 acres in size, has an existing structure, and the tax assessor card notes it as a retail office space. Tax assessor lot G08098 is 0.535 acres in size, is vacant and undersized for the RA40 zoning district. And finally, lot G08029 is 3.602 acres in size, and that's the former location of the Willcroft Kennels. Based on the proposed zone change map, which was submitted with the application, there are areas of steep grades across the property. Rezoning would allow changes in use on all the properties to any use allowed in the RMF10 zone. It's a multifamily zoning district, allows a greater number of uses and more intense list of uses than those in the RA40 zone. There are as well general use regulations associated with the RMF10 zone uses that would dictate any development. And so for purposes of a residential density comparison, if you were to combine those 3 lots using the RMF10, you would it would allow 22 units, or 1 per 10,000 square feet of lot area, compared to 5 units under the existing RA40 zone. And that, as we indicated, is not an insignificant increase. And considering the grade differential across the land, site disturbance would be required to provide for multifamily structures and associated parking. Not only is there barely shared frontage with the RMF10 zone boundary across Pembroke Road to justify an extension of that district, but if you rezoned those properties as proposed, and I'm going to refer you back to the map, it would leave 2 properties immediately north on the same side of Pembroke Road zoned in the RA40. So that's an odd zoning scheme at best. In terms of the plan of conservation and development, the map designates the subject parcels as single family. On the POCD map, there are also notations of wetland areas along the roadside frontage of lot G08030 and in the rear of lot G08029. The RMF10 zoning district allows single family dwellings at a density calculation as indicated above at 1 per 10,000 square feet, the same as the multifamily density calculation. However, should the properties be rezoned, there are no assurances that single family dwellings would be constructed. Any use, again, we're talking about in the PLCD, any use allowed in the RMF10 zone would be permitted, subject to meeting the requirements. And as again noted, the 2 parcels would remain in the RA40 district to the north of the subject properties, a resultant zoning scenario that's inconsistent with good planning and general POCD policies and recommendations. And as you know, there are zoning regulations in section 10I3, the zone change criteria, and per that section, there are both general and specific zone change criteria. I'm not going to read you the 5 of them, they're all noted in there. I'll just kind of skip to the end to get to the chase. if rezoned, any of the RMF 10 uses, whether permitted or special exception would be allowed on the parcel to the extent design could be accommodated. While there is multifamily zone across Pembroke, it is not entirely adjacent to the land proposed for rezoning. The roadway geometry, I think we all know it, is also a concern should multifamily be developed. And the grades represent some challenges to development of a larger building or buildings required for multifamily. And in total, again, it would result in the loss of 5.14 acres of single-family residential zone property. And then there's the specific criteria for multifamily and mixed residential districts, and that includes a determination of the compatibility of the density permitted in the proposed zone with the surrounding residential densities, which should be considered along with the capability of the zone to act where appropriate as a transition zone between zones of different densities and intensities of development. The zone to the north is RA20, as I indicated, to the south and due east is RA40, an RMF zone in the middle, to which the petitioner seeks. The RMF zone is across the street and it only shares 70 feet of frontage, and that would result in a multifamily zone squeezed between the RA40 and the RA20, which hardly can be considered a transition area. The site should be conveniently accessible to collector or arterial streets and highways and transit routes, and consideration given to the impact of the development on the traffic safety and congestion on abutting or nearby roads, and the feasibility of undertaking improvements as may be necessary to limit the impacts to acceptable levels. The parcels are accessed from Pembroke Road at the curve of the roadway. This is a state road, and any improvements would likely be required for any change to a multifamily use. C, sites should be limited to those which will be served by public water and sewer service and where adequate capacity will be available, and public water and sewer are available in Pembroke Road. D, development on slopes in excess of 25% should be avoided, and these subject properties have areas where slopes are in excess of 25%, and therefore construction of a multifamily dwellings or extensive development across the site, if the lots are combined, would require slope disturbances. And finally, E, sites which contain a preponderance of wetlands and sites which lie within the public water supply watershed should be avoided, and site development would be assessed for potential impacts to wetlands, if any, at the time it is, and the land is not, this land in particular is not in a public water supply watershed. So in conclusion, notwithstanding the existing non-conforming uses on 2 of the 3 properties proposed for the rezoning, the existing RA40 district seems the most appropriate zoning given the existing zoning scheme, the location along the curve of Pembroke Road and the existing grades. The transition to multifamily across Pembroke Road is provided by the RA20 zone to the north of the subject properties. The subject site barely shares a zoning boundary with the RMF 10 across the road. And additionally, as noted, leaving 2 parcels in the RA40 zone is not appropriate. And for those reasons, we do not support change of zone. And then finally, there's the paragraph about what the planning commission would report to the zoning commission, which I think it did, and then to approve the petition to amend the zoning map. The zoning commission must find is considered the POCD as required by statutes, and that the zoning meets the zone change criteria of the zoning regulations. Rezoning should result in the use of land that is in the best interest of the city and will not detrimentally impact the health, safety, and welfare of the public. That's the staff report.
Thank you, Ms. Calitro. Is there anyone wishing to speak in favor of this petition? Attorney
Mr. Chairman,
Marcus.
if I may, thank you. Attorney Neil Marcus, Conewall PC 158, Deer Hill Avenue, Danbury, Connecticut, and I'm here on behalf of the applicants. So if any of you are familiar, and hopefully you will be before you make a decision on this application, with Pembroke Road, you'll have to come to the conclusion that it is the single most inappropriately zoned section of Danbury that you'll ever drive through. Starting right here, starting at this property, and I'll elaborate on that, but as you go, we'll look at this property. So first of all, if you look at the staff report, this is prime single-family 1 acre residential. That's what it should be according to the staff. That's what it should be according to the zoning. there are barely any new single-family residential houses that have been constructed on Pembroke Road in the last 40 years. But if you go up Pembroke Road, you'll see all the houses that used to be there have been converted to different uses. Now, this particular site only has 70 feet in common with the RMF 10 across the street. But if you're driving up Pembroke Road northbound towards New Fairfield, and you come to the intersection of Pembroke Road and Padenham Road, and you say, what is this area look like to me? No one in their right mind would say 1 acre single family, because it doesn't exist. And it really hasn't existed in the last 40 years. The first and last cafe and its predecessor, and now of course the Q, has been a restaurant / restaurant bar for years, forever. I can't remember quite honestly when it wasn't there. That's in the RA40 zone, and that is not RA40 use, never has been. The predominant neighbor, basically a third of the area of the proposed zone change, is the amber room. Well, what's the amber room? That's not prime single family residential. That's actually the RA20 zone and the let me just look here, and the RA40. It's 2 zones, but neither of those exist on the site. It's a huge restaurant. I mean, it's a catering hall. And so across the street, we got a nice restaurant. Behind us and around us, we have a nice restaurant. To our south, we have all sorts of commercial uses coming up Pembroke Road. And to our north, we start transitioning into a whole hodgepodge of commercial uses. Now, is the FCI, well, Hallis's Farm is certainly commercial. And if you go to the FCI, I mean, is that commercial? It's institutional. It certainly is not conducive to RA40 development. As you continue further on, you get up to a whole area that is still zoned residential, RA40, and it has strip centers with restaurants. It has an alarm service building. It's got an electrical contractor. It's got, you got a school over on your left, which is a residential use. And then you continue on, you have a gas station and you cross into New Fairfield. That's all residentially zoned property. And it is all improperly zoned because the zoning doesn't match any of the uses on Pembroke Road that have existed for the past 40 years. So on the subject property, we don't have any residential uses. We've got an old dog grooming site. We've got kind of a mixed office, small business site. There's nothing on the area in the 5+ acres that is residential. So when my client came to me and acquired the property and wanted to basically renovate this site into a better use, we talked about what would be appropriate. And of course, appropriate is really dictated by Stetson Place. That's the appropriate use. It still sounds in residential, but of course, I do agree that there are some other uses in the RM10 zone, but my client's not going to build a cemetery, I can assure you that, or a church. He's probably not going to do daycare centers or continuing care facilities, and I doubt he'll build a firehouse. Garden apartments, yeah, I mean, that's apartments are appropriate. We're not doing a nursing home. I mean, parks, playgrounds, and police stations. I mean, those are the other uses. But this property is meant for multifamily development because the most recent development in the area is Stetson Place. And if you start a little further down Pembroke Road in the area of Jim Barbary's, you've got all sorts of multifamily residential uses that have developed along Pembroke Road for years. So the proposed zone is logical and realistic. And it's not going to have a negative impact on the neighborhood. What it's going to do is it's going to allow us to make the uses that are all non-conforming on this site conform, if we can just get some zoning regulations to conform to. I will assure you that it's very unlikely that you're going to see 3, 4, or 5 single-family homes on this site, because it's just it's inappropriate. So if you want to have a reasonable use of property, then we need to consider the change. So now we have to look at whether we can agree with the staff report on the criteria for change. The description of the nonconformity of this property and the description of the uses adjacent are correct. We don't dispute that. But we do question whether you can anticipate that an RMF rezone would be something other than some type of residential use. And then the question of whether this meets with the plan of conservation and development lies in a reading of the actual zoning regulations that exist under the plan of conservation and development. And first of all, if you're talking about the discussions of a new plan of conservation and development, there's been a recognition in the reported meetings of the committees that there is a need for additional affordable housing in Danbury, even not necessarily 8-30G affordable housing, but just affordable housing. As a matter of fact, that was the lead story on NPR this morning on WSHU, the national shortage of affordable housing and the disaster that that's going to impose on our economy. But we do need different types of housing. And the concept of 1 acre single family homes is really a concept that is more historical than forward looking. So the idea that this property would be changed to multifamily is the trend that housing is taking at this point. So the plan of conservation development has to recognize that. But right now, the general purposes of the RMF zones are contained in 4B1A paragraphs 1 through 5. And I'll go to a couple that really apply here. A fifth one is to promote diversity of housing types and character and to encourage the development of affordable housing in the city. I mean, that's in the zoning regs now. So why doesn't it meet the plan of conservation and development? Do we have zoning regs that are that far out of sync with our own plan of conservation and development? I don't think so. And then if you look at paragraph 4B4B, it says for the RMF 10 zone, in addition to the 4B1A criteria, it is a specific purpose and intent of this zone to permit low density housing for a range of dwelling types in areas with environmental constraints. Well, the staff report has said you've got grade on this site. So that might be an environmental constraint. Staff report says you got some wetlands in the front. That might be an environmental constraint. So this property meets the description currently of the zone. And then it goes on to say, and to promote where appropriate, a transition zone between single family neighborhoods and more intense forms of development. Well, to the extent that there's still property to our north that's RA40, that's the single family neighborhood, then this property is in fact the transition zone, because everything across the street, behind it, and to the south of it is a more intensive type of development that's referred to in the transitional zoning. So the concept, I mean, the plan of conservation development, in fact, envisions this type of housing, this type of zoning for this type of property. Not to mention the fact we're on a very busy state highway. A lot of people don't build single family 1 acre residential homes on busy state highways. As a matter of fact, very few people do. So again, if you want to put blinders on and say, well, the problem with this application is you didn't go to the two people to the north and get them to join you, is to basically to turn a blind eye to the realities of what we can accomplish. If this transition zone occurs here, then there's a chance that the property next to it would join. They would have a good reason to join into the same zone. And for that matter, the property to the south as well. So you'd have a whole block eventually. But we can only start with the property that we own to bring to start the process going. And that's clearly what we're doing here. The staff report, again, talks about the two parcels to the north, and that's like the tail wagging the dog. And that's just not good forward-thinking planning or zoning. The criteria, as I say, we meet the criteria of the zone, and the criteria that's set forth on page 3 of the staff report, we pretty much meet too. The compatibility of the density permitted in the proposed zone with the surrounding area. Well, the surrounding area is commercial, and across the street, you've got a major multifamily development, the most current construction in the neighborhood. And that's what you look at. You don't look at neighborhoods as to what was built 50 years ago. You really look at what was built 5 or 10 years or 15 years ago, because that reflects the compatibility of the neighborhood. So on page 3 of the staff report, we do meet paragraph sub A. And paragraph sub B, site should be conveniently accessible to collector or on a state highway. There is no road that is more accessible to a collector road, no site that's more accessible. The sites should be limited to those served by public sewer and water. We have that available to us clearly. The developments in excess of 25% should be avoided. And that's the very reason you don't try to put a house on 1 acre on this property, because you've got slope. So you want to cluster it, and you cluster it by doing the RMF 10 zone. And then the last thing is sites which contain a preponderance of wetlands, well, or lie within public water supply. That doesn't apply here. We're not within the public water supply area, and we have a very small section of wetlands, which are basically caused by road drainage from Route 37. So the criteria for changing the zone really does exist. If you read it and look at reality at what the site is and can be. So we go back to our statement of purpose in the zoning application. The proposal is to change the property to a zone which will allow for residential uses other than the single family, which meets the general purposes of 4B1A and B, as we've gone through, and that will permit low density housing for a range of dwelling types to provide, where appropriate, a transition zone between the single family neighborhoods and more intense forms of development. In reality, I will tell you from a textbook point of view, and based on the existing development of land use patterns along Pembroke Road, there is absolutely no property that is better suited to be in the RMF 10 zone. And it, as I say, I can't disagree that the other properties adjoining it should join at some point, but I can't really, there's no basis to deny a legitimate zoning application because the neighbors want to continue to use the property in a manner that is not consistent with the zone that it's in. We can't control that, but that's not a legitimate criteria for denying, even though there's a suggestion that it is. I can't find that in any textbooks. So the opportunity, and again, like everything else, you say, well, what happens to this property, Neil, once your clients now have invested in owning it? What are they going to do with it if they can't develop multifamily housing as they propose? Well, what we're going to do is we're going to go back and we're going to redo the traditional non-conforming uses. So basically, it'll be a commercial site. It's never going to be RA40 because it's a commercial site now. So we're going to be forced to do a site plan that hopefully with a few minor variances will allow us to improve these dilapidated, for the most part, buildings and come in with maybe an office use, maybe a dog kennel, maybe a barber shop, maybe a hairdressing salon, something that has been used on this site traditionally, though it's non-conforming. So I don't want to do that. And by the way, that's not the highest and best use of the property or the neighborhood. So what we would propose to you is allow us to, I know it's only 70 feet across the street. We've heard that a lot tonight, but that 70 feet is the predominant and domineering land use in the area. And I know you'll be anxious to close this public hearing tonight, but I'm going to tell you, if you do, you'll be remiss in not taking a ride up Pembroke Road and slowly and taking a look to your left and to your right. And as I say, this site is easy to identify because there's a really popular restaurant across the street and there's the Amber Room right behind it. And you can see it. And if you can't, you'll just come to a gut feeling that this property is not single family residential. It just isn't. And the best use, given what's there, is this multifamily use. So I disagree with the textbook analysis in the staff report because I think that the language of the zoning regulations refutes that. But the real proof here, I hate to say it, the proof is in the pudding. It is. The proof here is to take a look at what I will go back to say is a disaster of a zone along Pembroke Road. It needs to be corrected. We'll start here. And quite honestly, I've got clients at the other end in the gas station and in the little strip mall up there that would like to change their zone to reflect what they want, what they've been all these years. The problem is that I can't quite figure out under our current zoning regs what that zone is. But the answer is they're in a residential zone. This is in a residential zone, and none of these properties are residential. And it could be multifamily, but single family just doesn't exist, hasn't existed in years, and is unlikely to occur in the future. So take a hard look at this, and I'd be happy to answer any questions. But in reality, it's a sensible revision to the zoning map. Thank you.
Thank you, Attorney Marcus. Commission members, any questions of Attorney Marcus at this time? Commissioner Melillo.
As expected, Neil, right?
God, you're more predictable than I am.
So yes, that will lead to one of my questions, by the way, but I'm not going to go there first. First, I do want to point out that I am familiar with this section. Both of my daughters went to Pembroke School. I live on the closer to Golden Hill. So obviously every time we did anything school related, I drove this way. So I in fact, I just, not because of this petition, but I just drove this route the other day because I was curious since the section of the road had been closed over the weekend because the electrical wires in the situation queue. So I've just driven this road. And so first, I just want to ask, because I have a feeling this might come up. Probably somebody speaking in opposition might throw this out. So I want to throw this out now in advance in anticipation of that. With those two lots remaining RA40 and the rest of it being rezoned, would that result in a spot zoning issue?
No. And the reason I say no is that you don't create spot zoning is when you create a zone that is out of sync with what's in the neighborhood. You don't create spot zoning by leaving currently zoned property the way it is. But in reality, good zoning would probably rezone that property in the future, because again, it is no more RA 40 on the north end than it is on these two sites. But I don't think you would be accused of creating a spot zone, because you're just leaving existing zoning, and what you're doing is creating a new zone. But the 5-acre parcel is too big to be a spot zone. And the fact that even though it's only 70 feet on the road with the existing adjoining zone, it adjoins it. It adjoins it. It would be an oddly shaped zone. And the better way, as I say, would be to take all the properties around there and consistently make them RM10. But I don't think that an appeal of the zoning decision creating this zone on the basis that it's now created a spot zone would lie. It's not the traditional spot zone.
Okay, thank you. And my next question, I've been trying to think as I drive up through this section, and again, I'm familiar with the fact I believe I've been in one of the houses that was on one of these parcels you're talking about, because not recently, it was years and years ago when I was a child, having grown up in Danbury like a lot of us did, my parents had friends who lived there. So I do remember being in a house over there visiting them, because when I drive by it periodically, say, oh, I've been in that house, as we have those memories sometimes. Oh, I've been in that house. So as I'm thinking about this, I can think of the little, I'm gonna call it a little strip mall for lack of a better term, where Jeffrey's Chinese Kitchen, there's a barber shop. Ironically, there's a package store there. And I think maybe Candlelight Electric or something has some trucks there. But outside of that little section, I'm having a hard time on the right-hand side of Pade Narrum Road, remembering what the other commercial uses are besides that one little section on the right-hand side. Can you fill me in on what the other commercial uses are?
Well, there was like a small auto body shop there.
That's on the other side by the Flag Rock.
Well, hold on. Well, maybe I'm not sure which side you're talking about. If you go northbound on Pembroke Road.
Yeah, no, I'm talking about if I were to turn right off of Jeanette, okay, and head up towards this section.
Towards New Fairfield, yes.
Actually, so you know what?
Yeah, you pass that.
I do pass that auto body shop. Yeah, I was forgetting about that. But other than that auto body shop, is there on the right-hand side?
Well, there's not a lot of development on the right. You got a steep bank up there. There's a whole section that really doesn't have many structures at all. There may be an old house up there that I can recall, but I mean, it's up a pretty steep grade. Even the auto body property is built into the hill.
That is on the auto body shop, because then it goes around the curve, but then I'm thinking, besides the little plaza where the little Chinese restaurant and all that is, it seems to me as though the bulk of that is our houses.
We'll go back and take a look at them. I think you're going to see a couple of houses, but they're not RA 40. Those are not 1 acre lots. I mean, those are what I will call pre-existing non-conforming. They're probably at best a half an acre, but but they're not traditional single family 1 acre residentials, and they're all sort of left over. Nothing's new, because the newer stuff has been commercialized over the last 20 or 30 years.
Right, but couldn't a pre-existing non-conforming, if there was an issue, you would be able to rebuild in those dimensions and parameters, correct?
Correct. Yeah. But again, I just don't think that it's proper zoning, because it's an RA 40 zone at the moment.
Okay. Which brings me now to my last question, which a little bit of a predictability, like you said, with you being predictable. From time to time, a lot of attorneys come before us, and they ask us for a rezoning to extend the zone line to the street, because Ms. Calicio already mentioned in her staff report the idea of good planning, but a lot of attorneys use the term good zoning and tell us that good zoning takes a zone line to a street and makes a street be the zone change line along those aspects. Here, You are asking us to do the opposite. It seems like you're asking us to take the zone, extend it over the street to a couple small parcels, you know, into it, therefore kind of creating a different zone. So would this contradict with the idea of good zoning?
No, this is right on. And you can thank Zach Rapp. The proper way to draw a zone map is to put the zone line up the center line of the street. That's what he's done. He brings the parcel you're talking about is really the state highway. We've extended the zoning to include the center line of the state highway.
So I might be confusing. Are you asking us to change to RA 20 or RMF 10? I was thinking it was RMF 10.
Yeah, so RMF 10 will extend to the center line of Pembroke Road.
Yes, but with this zone change, RMF 10 then would then go
and across the street. Hold up, across the street.
It would cross the street into these two parcels here. But therefore the RMF, now you'd have a zone change along a lot line instead of a zone change along the street, correct?
No, our zone line that we've proposed here on our map is up, goes up the center line of Pembroke Road. It's in the middle of the street, which is the proper place to put it. It should not be, because otherwise what you would do is you'd have your zone line at the front property line of my client's property, and then the road would essentially be in the RA 40, which is the zone line in front of the Q. So the zoning line in front of the Q is RA 40. So we're taking the road and we're splitting it by the two zones.
Yeah, because when I look at the picture that Ms. Calicio provided in her staff report, I'm looking at RMF 10, and then I see Padenham Road, and then on the other side of Padenham Road, we're talking about 3 parcels with those little red dots on them. So it seems to me as though we'd be taking the RMF 10 zone and having it cross over the road into it, and rather than having Padenham Road itself be the zoning boundary. You're creating a scenario where the RA 40 zone would be on the left and right of Padenham. Then
well, actually,
RMF 10 for the left and right of Padenham, then RA 20 RMF 10, and then back to RA 40 RMF 10. Then you would get back to the full RA 40.
The better description is to look at the zoning map that we've submitted, because first of all, it's a much larger scale. If you look at the zoning map, what you're going to see, and then relate it back to the 3 red dots. The 3 red dots are our zoning map. And the line for RMF 10 goes up the center line of Pembroke Road. On the other side is a small triangle of property, which is the Q, that's still in the RA 40 zone. And actually, that's really pretty much a spot zone, because, well, not really though, because it's separated by RMF 10, Stetson Place, and then RA 40 picks up again beyond Stetson Place. So you got a little sliver that comes down in between. But the zone line that we're creating is the center line of Pembroke Road, but it shows better on the zoning map. It's too small. You can't see it on here.
Yeah, see, I would think though, if anything, just to make it a cleaner line, we would extend maybe RA 20 rather than RMF 10 and leave Padenham Road. Again, just with that idea of maintaining the street being the zone line.
So you're suggesting that we bring RA 20 down from the amber room and encompass this piece?
I'm just wondering if I'm not saying you should. I'm just saying if that wouldn't be more consistent with the idea of good zoning, maintaining the street being the zone boundary rather than having the zone boundary cross over the street and then having the zone boundary being a couple lots.
Now, Bob, we did think of that and we considered that, but quite honestly, we looked at the grade in the back of the property and we said that if we did RA 20, we could come back because we have 5 acres with a cluster. And the problem is that the site doesn't lay itself out for that type of design. It lays itself out much more for multifamily, which is a more clustered, but it worked better. So we dismissed that approach as being, again, it was kind of a compromise to say, well, we'll make it half of an RA40 zone, we'll make it RA20. But at the end of the day, everything around it is still so non-conforming because it's either commercial, the Amber Room, the Q, or the places we've talked about going up Pembroke. And then, as I say, ultimately, you get up to the Hallis in the penitentiary. So we just felt that this zone, based on the language of the zoning regs, actually makes more sense than RA20. It's just more appropriate.
I don't have any further questions, Mr. Chairman.
Thank you.
Thank you, Commissioner Malone. Thank you, Attorney Marcus. Commissioner members, any other questions of Attorney Marcus at this time?
I do.
Commissioner David, go ahead, please.
Yes. So Attorney Marcus, did you want to do any traffic studies yet there? Did you do any studies about the Pembroke School, how it's going to impact the Pembroke School? How about the accident studies there at that Q intersection? Was a nightmare trying to get out of there. The traffic going down 37. How about it?
Well, no, we will do all those if we have a zone change that we can develop a site plan and a use for. At the moment, if we go to a traffic study, we'd have to spend a lot of money with a traffic engineer saying, come up with a use that's not allowed in the zone today and do a traffic study for us. And again, we normally don't do that. But the answer to your question is, if you rezone this, a use would have to come back to the planning commission and they would require, as a special exception, they require a traffic study. And of course, the traffic issue ultimately is controlled by the state of Connecticut. I think Sharon Cletro points that out in her report. Ultimately, traffic on Pembroke is controlled by the state. I mean, conceivably, the state could say that you want a light at the corner of Pembroke and Paden-Aram. I doubt it, because there are other traffic controls that they've just put in to deal with that. They just put in one, up by the Amber Room, just up the road north of us here. They just put in a whole new intersection with a light. And then you go down and you get to the garden center and you get another light there. And the state will tell you whether those two traffic lights can control the traffic that we're going to generate on this site. But you are correct that we need a traffic report ultimately. But first we got to figure out what do we want them to report on? And if it's between you and me, if it's 3 or 5 single family homes versus the pre-existing non-conforming businesses versus a multifamily development, those are a lot of different traffic reports. So we'll do it, but we haven't done it yet.
I got one more question for you.
I got a question for you. Hold on. I got a question for you. I want to know.
I got a question for you first.
I want to know what it takes you. What it takes you. It takes you 3 minutes to walk 1,000 feet down the golf course, and Ken Glucker can do 2,000 feet to the Q in the same 3 minutes.
Well, come on. His legs are about 8 inches longer than mine apiece.
Nice. What's your question?
He's half my age. Well, he looks twice as old, but he's half my age.
What's your question?
Commissioner David, what's your next question?
Well, I want to ask you, you keep referring to this as a transition section. Transition, what do you call it? Transition
zone.
Transition zone.
Yes.
So what are you saying, that you can put 22 units there, in the next year or two, and then your Amber Room bounces in another 200-300, and then one behind that's another 200-300. Is that what you're saying? How it's going to straighten out the zone there? Is that what you're saying?
No, I'm just saying that I'm saying that multifamily, and if we can do, we're given the layout of the site, I'm not sure you'd ever get 20 units on there, but assume for a second we got 15 units. That is a transition which basically will make it look a lot like Stetson Place across the street, and will be the proper zone between the commercial section of Pembroke and the residential section that might be up across from the Marjorie Reservoir, where there are actually single-family homes that are there in the neighborhood. But before you get up towards the Marjorie Reservoir, you don't have a hell of a lot of single-family homes at all. So Bear Mountain Road starts the more traditional residential on the east side of Pembroke Road. So the transition is as to what is there today. I can't project what happens to the Amber Room. It serves given the number of functions that people have in the city of Danbury at the Amber Room, it serves a public purpose as a convention center, a catering hall. But if it were ever developed with the land that's not used there, the residential use there is still RE20 or RE40, and this is the transition, which is appropriate when you have a state highway. That's the other thing you're transitioning from. Good zoning doesn't build single family RE40 on a state highway, because you'll see that problem is you get up to the Marjorie Reservoir and you try to get out of some of those driveways up there. Those are the ones where you take your life, depending on the time of day. But take your life in your hands, I should say. But here, it's a transition given the highway and the existing uses, period.
Thank you.
Thank you. Thank you, Attorney Marcus.
Anything else, commission members of Attorney Marcus? Attorney Marcus, before I see if anyone else did you mention that your client already closed on this property?
We've owned one of the lots, and the other two lots are under contract.
Okay.
And the problem is that the Morsi family had an estate issue because I think when Bob Lillo was talking about who lived there, the Morsis did live there many years ago. And when they passed it down through the family, they didn't clear some of the estate issues, which we'll have cleared up in about 2 weeks and we'll close. So we've been waiting just for the probate court.
Got it. So they're actually purchasing, they have an existing, and what they're purchasing is the Willcroft Kennels.
Yeah, we own, well, the kennel we own.
Oh, okay.
That was the Baudelaire property.
Okay.
Morsi property that's still waiting closing, but it'll close.
Thank you. Commission members, anything else of Attorney Marcus at this time? Commission members, anything? I don't see or hear anyone else wishing to speak in favor of this petition. Is there anyone wishing to speak in favor of this petition? Is there anyone else wishing to speak in favor of this petition? I'm going to go to page 2 and ask one more time, see if I see any hands. Anyone wishing to speak in favor of this petition? I see someone that says Sean's iPhone. Did you want to speak in favor of this petition? I'm glad I went to page 2. Sean's iPhone, unmute.
Hi, I'm Sean's wife, and he's not in favor.
Oh, so then we didn't get there yet. I'm talking about those in favor. Okay.
Right.
Sean's iPhone, you have to wait. Is there anyone else wishing to speak in favor of this petition? Now I will go to those wishing to speak in opposition to this petition. Is there anyone who wants to speak in opposition to this petition? Ms. Calitro, I think you have a couple letters there.
I do, Mr. Chairman. I wanted to read them into the record.
Please,
So
thank you.
I got 3 emails.
Thank you.
So let me think. I get August 7th again. August 9th. Okay, so I got the first one is to me from Alice Trotta, 3775 LLC regarding the above referenced project. I'm strongly opposed to this petition due to increased traffic flow and major concerns on Route 37 around a sharp unmarked corner, resulting in 2 deaths and serious injuries over the last 3 years. This is not in any way a positive change for our neighborhood and the general area Respectfully, Alice J. Trotta, 42 Stetson Place. The next one is from Fred Huber. I'm writing to you regarding the above application. I am totally opposed to the change 5.39 acres of land, single family, RA 40 to high density RMF 10. This area has so much traffic on Route 27 already. There have been many accidents near the corner resulting in deaths. This is not a positive change for our neighborhood and the general area. Please consider our review. Respectfully, Fred and Joan Huber, 45 Stetson Place. And finally, from Roseanne Shepis, they were trying to get to me, I guess, and it got bounced back. So it says, Dear Chairman Haddad, as a resident of Stetson Place, I'd like to express my opposition to the above application for zone change, as I have to negotiate existing high traffic volume on a daily basis, especially turning on and off of Route 37. I can attest that we do not need additional residential or commercial units in this area. Also note that the proposed land is on a sharp curve at the intersection of Payneham Road. Please do not grant this application. Thank you for your consideration. Rosanna Shepis, 61 Stetson Place. That's it.
Thank you. I was just jotting down the addresses. In opposition, I see Representative Ken Gucker. Why don't you go first, please, sir?
Well, thank you, Mr. Chairman. Normally I go last, but I'm going to tell you, I have no air conditioning in my office, so I'm losing weight by the moment as I sit here and sweat beyond my normal working. But I do, normally I'd wait till the end, but there were a few things that really, bothered me with the proponent's proposal. I will say this Halloween, the 31st, will be 31 years I've been living in this community. I grew up in New Fairfield, and all except for 3 years of my life, I have been driving up and down Route 37 my entire life. Now, I wasn't allowed to drive at 3 years old, so, even though my father would put me on the tank of his Harley and drive up and down the road, I still don't remember much of that, but still, I do have a good perspective as to what the conditions are on this corridor. As to the idea that no single family houses have been added for at least 40 years to this area is simply not true. Let's go look at many years ago that Jean Natal's property, which is where the body shop is, and 5 acres and a few others. There was an attempt to change his property to RMF 10 back then. When that did not happen, the property located at 63B Payneham Road, a single family house was built there. Okay, so, and that's within the last 25 years. When we talk about, the neighboring community as far as Stetson Place being, oh, well, you allowed you allowed RMF 10 there. No, we did not. What happened there was because Danbury was below the 10% affordable housing clause that is put in place by 830G, that we had no choice but to accept that property, because for many years, BRT tried to put condominiums in there, and they were denied by commissions, by members before your commission because of traffic, road conditions, and other areas. The idea that there's going to be low density housing. Well, what's lower than single family housing? Single family housing. Proponent hasn't really told us what they're going to do here, but what they're not telling you is the environmental impacts as far as also the disruption to the community. Because if you look at the typographical maps, you're looking at an 85-foot differential in elevation, which is going to allow blasting, removal of stone, and other things, which I can tell you, when Stetson Place was built, my house to this day that was built in 1966 is still settling. I have leaks in my basement. I have doors that don't close properly, and I custom built and hung every door myself, knowing that they were done right proper, and everything was fine until Stetson started blasting. And actually Stetson would have been a larger project had they not hit so much rock on the backside of Bullet Hill and Cannon Road. So to think that this is an improvement is not. To say that there's commercial property, this is the best use. I will also say that the owner of the plaza where Jeffrey's Chinese is in a liquor store, he thought today that he could come to City Hall and speak in person, and called me from the door and said, I'm locked out. He doesn't have a computer. He doesn't have ability to talk in front of this group. But here's a major business owner who says, no, I don't want this. Drove down to City Hall, and unfortunately, because of access, couldn't get in to speak on those issues. Hallis Farm, yeah, it's a pre-existing non-conforming, which we will get into later date on really how much is really pre-existing and how much is not conforming, and really how much actually deserves to be there. When you drive up and down Route 37, which I have been doing my entire life, except for 3 years, it hasn't changed much. What we've seen is this constant, this idea that we're going to make things better. Many of the reasons why I had an issue with Hallis Farm back in the day was safety around a deadly corner. Anybody who tries to leave Jeffrey's Chinese restaurant or his liquor store is taking their lives in their hands because it's a bad corner. I don't know how you're going to make the sight lines work. I don't know how you're going to make this thing to be safe for people to go in and out. And quite honestly, I don't understand why we're even looking at this, because all one has to do is drive across the street and look up at the 85-foot difference in elevation between the front line and the back line of how you're going to put something in there. Now, the applicant hasn't talked about what they're going to do. They're just changing the zone. Could be anything. But you as a zoning committee have to look at all of the possibilities of what could happen under that zone. I see it as residential multifamily as more condominiums. When we talk about the Stacy Road interchange, nobody knows that issue more than me. I've been living with that nightmare for 4 years. And yes, it's an improvement. In fact, I took the state engineers down right around the corner from the queue to look at the S-turns that are right by this property to say, here's your next problem. Now they're considering it, not going to promise that they're going to deliver, but they're considering that. To have individuals who do not live in this community, who do not understand my house is 2,200 feet from this intersection. The traffic is so bad, it is quicker for me to drive all the way up to 7-Eleven on Clapboard Ridge and drive down Clapboard Ridge than it is to try to get down a road that's half the distance down 37. But yet again, we don't know the traffic numbers or the incidents. Well, I'm going to be very simple about this. Westcog did a traffic study. They did a traffic study from North Street Shopping Center all the way up to the Senior Center in New Fairfield. I'm going to tell you, 20 years ago, the traffic studies at the Pembroke, the Peyton and Pembroke intersection were 19,000 cars a day. 19,000 cars a day. We're not talking about some small country road that people are running down. And that was 15, 20 years ago. As New Fairfield grows, as Sherman grows, as all the towns north of us grow, and the only manners that they have to get in and out of their communities is Route 37 or Route 39, we here in Danbury pay the price. My friend used to own the body shop, or used to operate out of the body shop that Gene Natal owns, one of the pre-existing non-conforming lots. And he used to stand out there every morning 20 years ago with a clipboard. You know why? Because the cars would run into each other. And he'd wave them in, and he'd write an estimate, wave them back out to work, because it happens every single day. And if you think of 20 years of growth that things have gotten better, they haven't. I will also mention that this weekend I spent my time going out to the neighbors. And as though, the laws and the rules say that you have to notify the neighbors that there's going to an impending zone change and et cetera, et cetera. Stetson Place Condominiums was notified via Imagineers. Imagineers is their maintenance company. Imagineers never told the head of the committees or anybody living in Stetson, by the way, your life is going to change right across the street. If it hadn't been for me knocking on those doors and talking to the president of the commission, of the homeowner commission there, they would have had no idea what's going on over there. So the idea of notifying the public, yeah, it fits the bill of what you're required to do, but does it really fit the bill of what you should be doing? Not so much. This corner is a bad corner. Anybody who tries to pull out of either the queue, which used to be the first and last, because Neil, even now and then I still call it the first and last. I still remember the garlic pizza as I'm walking by, but it's the queue. Trying to get out of there, you take your life in your hands. Trying to get out of Paid Narrum onto Paid Narrum off of Pembroke, you take your life in your hands. There are people that live at Stetson Place that tell me as they drive by Paid Narrum Road, where it turns off and it becomes Pembroke, they put on the directional to tell people 100, 150 feet ahead of time, I'm going to make a left-hand turn so you don't run into me. It's a bad corner. The area is not suited for this. The area of this idea that it's going to complete the zone is not true. The RMF 10 that was done for Stetson Place, that was done under 280G. That was done under the Affordable Housing Clause of the state of Connecticut, where this board had no chance or no word to say this doesn't work. Because years earlier, BRT tried to put condominiums in there, and every year people on this committee, I mean, Ted, I know you've been there a while, but probably not back that long, but they said, no, the traffic on this road is bad. And unfortunately, those of us who live in that community had to live with it because 830G said, sorry, you're under the 10% clause. You have to allow this to happen. So to use that as we changed this zone for a good reason, it wasn't a good reason. This board and the people of this community had no voice. Our voice was taken from us because of that state statute. So to use that as a benchmark as to why we should allow this doesn't work. To have somebody come in and purchase these properties, they know, and I've said this a million times, they know what they bought. They know what the rules are. They know what the zone is. Don't come in here and expect to buy a Volkswagen and get a Porsche when you leave. It is not for us, the citizens of Danbury or the people of Danbury in this neighborhood to say, you know what? I feel really sorry you bought property that you weren't going to put a single family house back up there, which is what it's zoned for. And why is it called pre-existing non-conforming? Because the idea of a pre-existing non-conforming is once the property stops operating out of its non-conforming status, it will become conforming. But we have to use that now as an excuse on why we need to change it to something that was never intended. Now, what is the the line down the road of what we really want to do with Route 37? I don't know. I've got a lot of things I've been working on. I can't tell you how much work I did with Stacy. I can't tell you how disappointed I am with the intersection of Barnum Road. But at the same time, you know what's there. You purchased it. It's not a good lot. It doesn't work for much. And now you're expecting to blast the side of the hill or whatever they're going to do, because we have no idea, because we're hearing now could be multifamily, could be commercial, could be this, could be that. You know what? I'm not willing to open that door. You go in there and buy that property under those zoning expectations and what you're allowed to do, then you stay under that expectations. But you don't turn around and you want to put something in there that, by the way, most of these people or whoever's purchasing probably aren't even going to be living there. They're going to do what they need to do and they're going to leave. And the rest of us should be going, well, now what? So, you know, in closing, I know it was a long speech, but in closing, many of us have been up and down this road. 55 years I've been driving up and down this road. And from what I hear from Mr. Marcus about he doesn't know this and that, tell you what, Mr. Marcus, you and I can sit down. I can have a long discussion about the entire history of that road, right back to where half those houses weren't in there, when Stetson Place had a single family house there in a barn, when the Nixon Watergate people were at the prison, the whole deal. I can tell you all those stories. But to sit there and say that this is a positive change, it's been tried. It was tried on Gene Natal's property, didn't work. So they put up a single family house. And guess what? That house is doing really, really well. These other people, you know what? You want to put something in there? Fine. Clean up the house. You know what you got. You know what you bought. It's all good. But at the same time, you got to consider the public safety, which is not in case in this place because it is dangerous to get out of there. Number two, what it takes to do the kind of development you're talking about doing in there, or maybe we could guess what kind of development you're going to do in there, which is going to disrupt not only the people on Pioneer Road, but the people on Pembroke Road, the people on Tom Thumb, the people on the backside of all this, when you start blasting and taking out that hillside, and they have to deal with what I've been dealing with for 20 years when Stetson Place went in, and now I have water leaks, doors that don't close, and other problems because guess what? We trusted the engineers, the lawyers, and the rest to do the right thing. I'm not willing to do that, and I'm not willing to ask the people on my road or in my area to do the same thing. Thank you, Mr. Chairman.
Thank you. Commission members, any questions of Representative Gucker at this time? By the way, I remember it when it was the Hofbrau, then it was the old Hofbrau, then it was the little Hofbrau. So I go back even further. Anything else of Representative Gucker, commission members? No. So right now I see Deborah, is it Deborah Kennedy? Deborah Kennedy.
Yes.
Deborah and
Yes.
Sean yes, go ahead. You have the floor. Go ahead. Take your time.
Yes. Okay, so I live across the street from the queue. The proposed property that we're talking about abuts my property. I'm a single family home. My house was not built 40 years or more. Okay, my house was built 30 years ago. Coming out of my driveway, I pretty much do take my life in my hands every single day. I've got people that come to my house, including my stepdaughters, that will not make a left out of my driveway. They go right, and they have to turn around at the Q restaurant in order to go left. There are so many driveways on this road that are blind drives to the people on 37 who all speed. I'm sure anyone who lives around here knows these people fly. And I got to look left and right as fast as I can and gun it to make a left out of my driveway. It's a very dangerous area. Stetson Place was put there. I'm sorry what happened to Ken Gucker. It was put there. I have friends who live there. Same thing. takes her 8 to 10 minutes to get out of her driveway to take her son to Pembroke School. I mean, you're talking less than a mile away, and she has to leave 10 minutes to get to school, less than a mile away. The traffic is horrendous, whether that's, state problem, it's a state road. The traffic is horrendous. Putting condos right here next to me is going to make the traffic worse. Now, in the last, I'm going to say year and a half since COVID, we all know a lot of people have moved into Danbury from New York, but they've kept their jobs in New York. So they use this road to commute. Okay, it's a little easier sometimes to go over into Brewster the back way than to get on 84 or 684. You could take the back way. The traffic is horrendous. Okay, so aside from that, one of my major concerns is the structural damage of my home. Now, we live with a lot of rock. I've built rock walls with it. I've built a waterfall with it. We've got so much rock on this hill, and we're talking about the same hill where they're proposing these multifamily homes, condos, whatever it may be, even if it's commercial. They got a blast, okay? I've taken my quad through the woods over there on that property that we're talking about. It's all rock. It's almost impassable. So they're going to have to blast. And now I have to worry that my single home, residential home, RA20, is going to be damaged. Now, if it gets damaged, what happens? I have to pay to get it fixed or have water damage. The value of my home goes down. Why? Because of structural damage, 1. 2, the value of all of these houses around me, all of my neighbors that I know, the value of their houses is going to go down. Why? Because you start putting all kinds of condominiums, multifamily, congestion, I'll call it, around our beautiful area here, our value is not going to go up. Nobody wants to live in a congested area. If they did, they'd live, go live on Main Street. Main Street's got so many multifamily homes, condos going up everywhere. Keep the condos, the multifamilies downtown by the transit stations. That's, people want to live like that. That's where they're going to go to live. Now you're encroaching, and I'll call it, into this beautiful parts of Danbury where we have single family homes, families being raised. This stretch, Route 37, if you've ever taken it, it's a beautiful road. We've got small local businesses, Jeffrey's, Vibe and Company Barbershop or hair salon. They're going to take down Mainly You Hair Salon, Candlelight Electric. These are all small local businesses that do great in this location because there is so much traffic, number one. What putting multifamily condos next to us on this road is going to benefit any of us? It's not going to benefit any of us. It's going to benefit the builders and their wallets. Okay? Nobody's going to be happy that I know around here with this, including the people who live in Stetson Place. I mean, they're in Stetson Place and the traffic is horrendous. I'm not saying that they shouldn't have done Stetson Place. They did it. I have friends there. I'm glad I have close friends, but to keep going and putting more and more and more on a road that's not even passable, I'll call it. Same thing with my driveway. It takes me, I'm not kidding, 10 minutes to get out of my driveway. I work 3 minutes from here. I work across the street from 7-Eleven. I own a business and I also work there. It takes me 10 minutes to get out of my driveway to go to work, which is 3 minutes down Padenham Road. So I'm completely opposed to this. I don't see any benefits for anybody. I don't want the value of my home to go down. I don't want congestion to make the value of my home go down. I don't want to worry about my safety. And I'll say that because you add more people. Now I live in an upper lot. Okay. My house is not down on Padenham Road. My driveway's 800 feet. So I can't see the road from here. I can at the bottom of my driveway, but these condos, multifamilies, I'm looking at the tags outside. I can see the pink tags on the trees on this proposed lot. It's right in my backyard. I had no neighbors. I have neighbors. There's upper lots going all the way down from my house. If you go down towards North Street, you've got a lot of upper lot houses back here. Great families, great kids. I don't see how this is going to benefit any of us, except make it worse. It's going to make traffic worse. It's going to make schools more crowded. It's going to be shortage of bus drivers again. I mean, it's been a nightmare with the schools, and maybe that should not be an issue with what we're talking about. But I'm trying to say, I don't see a benefit in commercializing this street or making it more crowded with more traffic, more people. You know, these little businesses, these little mom and pop shops that are around here on this road, even the queue, I mean, we're all just mom and pop shops. We're doing just fine. They're all doing fine. The only reason Rocco's closed was, unfortunately, he passed away. But guess what? Another one went right in there and she's doing great. Anyways, in closing, I just want to say I'm very opposed to it for many, many reasons. And I'm probably the closest one to these, property we're talking about. Vicinity wise, I'm right here and I'm not for it. All right. Thank you. Thank you.
Can I ask, I should have asked you in the beginning, or maybe you did mention, what's your street address, please, Miss Kennedy?
It's 71-A Padenham Road.
Okay.
I own 2 acres. I'm sorry, you still there?
Yep, I got you.
Okay. I own 2 acres, a single family home, raised ranch.
Got it. Thank you very much.
You're welcome.
Commission members, any questions of Ms. Kennedy at this time? Commission members? Thank you very much, Ms. Kennedy. So now I see Sean's phone. Sean's iPhone. You go ahead,
sir.
Sean.
Yes, sir. Can you hear me now?
Yes, we got you. You're good to go. Go ahead.
Thank you for having me. That was actually my wife.
So you live at the same address?
Yes, sir, I do.
Okay, thank you.
Any case, I just want to, she kind of summed it up. When I just want to kind of emphasize that when Stetson Place went in, my foundation cracked, my well collapsed, my well tank was filled with sediment. Let me see what else. Oh, I have a huge, well, we repair it now quite a bit, but I developed a huge crack in my sheetrock. And where they're going to blast on this property is probably 70, 80 feet from my foundation. I'm on a well, I'm on a septic. My neighbor is maybe 200 feet away from me. He's going to be affected that in where the interior lots. So there's a cluster of like 4 or 5 houses there. I'm really concerned, what could possibly happen if you guys did allow this. I kind of got blindsided by Stetson Place. And it costed me a ton of money. But, that and the fact that I've been hit twice pulling in my driveway. We're directly across the cutoff from behind the queue. So as I'm pulling in, people tend to think that I'm going to the queue because I do have a bigger truck. So I have to almost hug the yellow line. And I've been hit twice. I've sat at the bottom of my driveway, putting my son on the bus. You don't even want to know how many times the bus stops to pick up my son, and cars don't even stop for the bus. And there's probably, I would say maybe between the families here, 6 to 7 kids that actually wait along Route 37. That's a major concern for me. You know, God forbid something happens. So yeah, I just wanted to strongly oppose this. And hopefully everyone on the board will also.
Thank you. Commission members, any questions of Mr. Kennedy? Commission members? Thank you, Mr. Kennedy. Anyone else wishing to speak in opposition to this petition? Anyone else wishing to speak in opposition to this petition? Anyone else wishing to speak in opposition to this petition? And I'm going to go to page 2. Up, I just saw a hand go up. It looks like Lauren Brower.
Hi.
Hi, you're speaking in opposition to this petition, so go ahead,
Yes.
please.
A lot of things were already mentioned that I wanted to mention. I just want to let you know that or everybody know that I strongly am opposed to it.
Tell us your address, please, before I forget.
60 Stetson Place.
Okay, thank you very much.
And the traffic has become worse. I feel that ever since they put the traffic light up at Stacy Road, I know they tried to make improvements. It's made it actually more difficult with the flow of traffic getting in and out. And the pollution to my place because of the light and all the cars that are already stopped and backed up. And the kids can't even take the bus here because the bus can't cross into our complex because of so much traffic. The kids have to cross 37. And so I'm just strongly opposed to it.
Well, thank you very much. Commission members, are there any questions of Ms. Brower at this time? Commission members? Thank you, Ms. Brower. Appreciate it.
No
and
problem.
I also see another hand, Claudia Burnell. If you would unmute and speak, take your time, and also just let us know your address, please.
Yes, hi. My name is Claudia Bernal. We live at 73 Patternam Road. We are neighbors to Debbie and Sean Kennedy. And we also strongly oppose. Sean and Kennedy actually spoke a lot about, you know, why we oppose as well. There are about, I want to say 10 actually, about 10 kids that live in this neighborhood. And we are always worried when we're getting out of the driveway. It's very dangerous. Waiting for the bus as well is, you know, we have our life in our hands every single day, every time we get out of the driveway. So we strongly oppose, and that's, you know, one of the major reasons why.
Well,
And
thank you. Oops, go ahead. I'm sorry. Go ahead.
Sorry, I speak for my father as well. He lives upstairs, same 73 Patternam Road, and he strongly opposes as well.
Well, thank you very much. Commission members, are there any questions of Ms. Burnell at this time? Commission members, questions? Thank you very much, Ms. Burnell. Anyone else wishing to speak in opposition to this petition? Anyone else wishing to speak in opposition to this petition? Anyone else wishing to speak in opposition to this petition? I don't see or hear. I'm on page 1 and page 2. And no one else wishing to speak in opposition to this petition. Attorney Marcus, would you like to make any comments or responses to what you heard this evening? You're on mute.
Yeah.
There
Yes,
you go.
Mr. Chairman, you know, it's interesting that the comments that have been directed in opposition all have to do with the existing traffic conditions on Route 37 for the most part. And again, quite honestly, if you listen to all those comments, you would say, is this the place where you would build single-family residential houses on 1 acre? In reality, they've given us all the reasons why this is not a single-family zone. It's way too high traffic. It's got a lot of mixed uses that create problems on the road. It's interesting that all the reasons that people are opposed are really the reasons we want to change it to a different zone, which makes more sense. So the real question is, for example, if you look at housing in Danbury, multifamily housing actually generates a lot less school-age children than single-family 1 acre housing. So to the extent that a lot of people talked about the impact on their kids in the school bus, if I had some time, hopefully maybe you'll leave the hearing open, I'll address these traffic issues, because in reality, I don't dispute that 37 is a heavily traveled road. And I don't dispute that the conditions exist. But what I do dispute is that as a result of that, this property has to be developed for single family residences on 1 acre. I don't think that's the case, because quite honestly, I'd like to give you some stats on housing in number of children. And I have to get that information generally through the Danbury school system to update it. And actually, it's almost, I'd have to do it on last year's data for school bus stops. But basically, when we've done this study before, we've determined that if we built 10 to 20 units of multifamily, as opposed to 5 units of single family, that we would probably generate a lot less children, school-age children, being serviced on the site. And I'd like to develop that. The other thing that I can develop for you will be actual traffic counts, because if you develop multifamily versus single family, you have a lot less traffic going in and out. And given the fact that, we're talking about a site of limited development, the number of multifamily units, as I say, if we took the number of probably 15 on the site, and we took a third of that as single family, I will tell you that the traffic generation is not going to be significantly different. If you go to the institution of the ITE, will tell you that it'll be slightly more for multifamily, but not significant. And when I say slightly more, it may be 5 or 10 trips per day, which in reality, given Ken Glucker's information on the volume of traffic on Pembroke Road, is insignificant. It doesn't really impact that. 10 traffic trips more one way or the other is not going to make a difference. 100 trips isn't going to even make a difference. But the issues that have been raised by people who are in opposition, and interestingly enough, the bulk of the people who spoke in opposition live in Stetson Place. And what we're trying to do is say that, well, Stetson Place has changed the character of this property. So it's kind of a self-fulfilling prophecy that we're dealing with. But if you would allow me the time to develop some of the statistics that you're looking for to consider the comments, I can only tell you that years ago, when Judge Marshall Berger was deciding the case of Green versus Richfield, which was actually an early affordable housing case, and everybody in the neighborhood came out and talked about the terrible traffic conditions and the terrible conditions of the road. And the judge said, well, that wasn't caused by this applicant. And actually, there's no indication that the applicant will create that problem or even contribute to it. So therefore, it's up to the community, in that case, the town of Richfield, to fix the road and fix the traffic problem. Well, here, of course, it's up to the state of Connecticut to fix the road. And Ken, I believe he's being more than sincere in his statements that he's been working on it for years, and he'll continue to work on it. But to suggest that as a result of those comments, that this property is better developed as single family, 1 acre residential is not logical. And people see the problem, but we can't make a logical connection to keeping this RA 40. But I can demonstrate that more if I have a little bit of opportunity to get to some real numbers. But that would be my comment. I mean, I don't dispute that 37 is a heavily trafficked road. I don't dispute that the state may not have taken the proper precautions to deal with that. That perhaps this new lighted Stacy Road is just a Band-Aid that's not working. I can't comment on that. But I will tell you that all the arguments for traffic issues are arguments why this is not RA40 property as it's currently zoned. So with that, I would ask you to potentially keep the hearing open. We'll get you some more information and see where it goes. Thank you.
Thank you, Attorney Marcus. Commission members, any questions of Attorney Marcus? Commission members, any questions of Attorney Marcus at this time?
Mr. Haddad, I have a couple questions.
Commissioner Rea, go ahead, please.
He's alive.
So, Mr. Marcus,
Yes, sir.
you stated that your client already owns these slated properties, or they're in the midst of purchasing them?
Well, he owns one. When I say he, it's an LLC, but it's an individual. Right. And by the way, when somebody said that the people that develop these things just come in and leave, my client happens to be very local and has been around. Has been around and in business longer than most of us have been around Danbury. But anyway, be that as it may, he owns one property. The other property is under contract, and as I say, the only thing that's delayed the passing of title are some probate orders that are about to be issued. So for all intents and purposes, he owns it and will in fact develop it. The question is, as what? That's the only question.
Okay, now my second question is, I believe you stated that your client would, if we don't pass this petition, develop them as they currently are, which is commercial. Is that correct? Did I hear you right?
Yeah, again, I'm looking at this thing. So I would envision we got some first cuts of this property, but one piece is not large enough to cut it all. So that's going to remain pretty much as a non-conforming. And again, it's a commercial structure. The second part of the property would be entitled to at least one first cut. And therefore, in the back of the property, again, dealing with a grade, we could put a single family house. And the next question is, as we develop the rest of the property, we would have to probably do a subdivision to create another one or two houses. And the front piece, which is the old kennel, would probably remain as a pretty much commercial property. So I mean that's a development scheme that just comes to mind looking at it. Between you and me, the people that are worried about blasting and grading, yeah, I mean, as a single family property, it takes a lot of work.
But the commercial property referred to is, it's in a residential zone. Commissioner Rea, when he says commercial, he means that they're pre-existing non-conforming commercial uses, but it's still an RA40 zone. So if he gets denied here, he's not going to put in a new commercial building.
Well, I wouldn't say that, Ted, because we may reconstruct what's there.
Yeah, but you're not going to, but I think he meant I think he was saying that he got the impression that if you don't get anything here tonight, you're just going to go and put in some commercial structures. I don't know. I'm not speaking for him, but
no, clearly it's not going to be a stop and shop.
You're right.
Yeah, it's not going to be a stop and shop. You can't.
Okay.
Commissioner Rea, you good?
All set.
Okay, good. Anything else, commission members of Attorney Marcus at this time? Ms. Calitro, did you have any final comments?
I do not.
Do not. Commission members, our option is to yield to Attorney Marcus's request for further information, or if you think you already know through your experience as a commission and a citizen of Danbury what the answers may be, or any questions outlying, you have an option of continuing the public hearing or closing this public hearing. So commission members, what's your pleasure? Motion to close or a motion to continue?
I'll move to close the public hearing.
Motion made by Commissioner Fay to close the public hearing.
I second it. How's that?
And there's a second by Commissioner David, Commissioner Coelho, second by Commissioner Coelho. Any discussion?
He always acknowledges you.
Excuse me, can I make a comment?
No,
Oh,
sorry.
okay. I just, because I'm president of Stetson Place and we were not aware of this. And I only became aware of it yesterday.
Yeah.
So really, there's like a handful of
Yeah.
Stetson
Listen,
Place people
listen.
here, but if it would be, I'm asking. to
Listen.
extend-
Yeah, hold on a
extend
second.
the hearing.
Stop. We have a motion on the floor. And what I would suggest you do, since I've been hearing this, since I've been on this commission since the 1970s, is the next time your management company comes up for renewal, that you throw in their face the fact that they never notify the residents of any legal notices that they get. Because every condominium management association does not notify their members, and it infuriates me. But your time has passed because we've already gone past that point. There's a
Sorry,
motion.
I apologize.
That's not your fault. You just didn't know. It's okay. So, but we have a procedure that we have to follow. So there is and I'm sorry for that. So there's a motion to close the public hearing by Ms. Fay, second by Mr. Coelho. Any discussion? Any discussion? In fact, if we kept this public hearing open, you still wouldn't be able to speak. All those in favor of closing the public hearing signify by saying aye.
Aye.
All those opposed? I don't see or hear anything. So this public hearing is closed. Number 3 this evening, petition of 40-44 MPR LLC, property owner Robert Campisi, for a special permit for cafe liquor license for Revolution, 40 Mill Plain Road, E15110 in the CA80 zone. Where am I here? No, this goes with this. This goes here. Ms. Calicio, do we have anything here that has to get read in? My table is a disaster.
No, I mean, they submitted a copy of Jen's waiver approval.
Yep.
I don't think you need to read it into the record. It's
Got it.
in the record already.
Site plan, map, and floor plan are read in. Legal notice was already read in at the beginning for all of these. So I will just go right to anyone wishing to speak in favor of this petition. And I see that Mr. Benjamin Dodo's hand is raised. Mr. Dodo, you have the floor.
Yes. Good evening, Chairman Haddad, members of the Zoning Commission.
Good evening.
Benjamin Dodo, licensed professional engineer with an office at 248 Main Street. I'm here tonight. I'm the civil engineer for this property, and even though it's a cafe permit, I've handled a lot of the site plan and zoning approvals with this property. So I'm going to just go over that briefly. I know it's been a long night, and then I'll let Rob Campisi talk about the actual business that he's doing.
Sounds good. Thank you.
Okay. For those of you familiar, I think you all are, 40-44 Mill Plain Road. It's a 2.3 acre site in a CA80 zone. It's the former fun station site, used to be Rollerland years ago. The current owner, Mr. Ramadani, purchased it in about 2009. And over the years, he's remodeled the place, and we've gone through P&Z for site plan approvals, revised site plan approvals to get to the existing mix that's there. Currently, there's a vet at 44 in the front. The site has actually a driveway on West Kenosha. Even though it does have frontage on Mill Plain, there's currently two restaurants there, Mix 40, and their outdoor patio, Zen, and then there is a CrossFit gym and the vacant space that we're here for tonight. The vacant space is a 5,300 square foot unit. It was a portion of, prior to COVID, and it was in front of this commission, there was a Max Wine and Spirits. For those of you that remember, many of you were probably on the commission. Didn't have really good frontage, liquor stores up and down the road. I know we talked about liquor stores a lot tonight. Anyway, it closed before COVID, Max Wine and Spirits. CrossFit took up about 60% of the unit, and we're here for the other 5,300 square feet. A cafe is a permitted use in the C80 zone, but once you add the sale of alcohol, we have to come in front of you, and that's why we're here tonight. We received, as you mentioned, a waiver to site plan approval in June from P&Z. So the cafe was approved, subject to us coming here tonight for you, in front of you, and that's what we're here for. Just want to touch base real quickly. Mix 40, it's a restaurant. They have a liquor permit, as does Zen. And as I mentioned, the old liquor store is no longer there. As far as parking requirements, we do meet the parking requirements according to zoning. And one of the things that the property owner has been very careful with as he's tried to replace the liquor store is to even though we meet the letter of the law from parking, we don't want to have a lot of uses that have the same peak times. So, for example, that's one of the reasons the gym was taken. The gym and the vet tend to be busy when the restaurants aren't, and vice versa. And another restaurant here probably would have created a parking issue at night, from a practical standpoint. So the cafe, which tends to have lesser and later hours, it sort of complements the mix here. I'll be happy to answer anyone's questions, but I'll let Rob Campisi, he's here. He is going to be the owner of the Revolution.
Well, thank you very much. Shall we see if there's any questions for Mr. Dodo first? Commission members, any questions of Mr. Dodo? Not yet, but we may come back to you,
Okay.
Mr. Dodo. Mr. Campisi, you have the floor.
Yes, thank you, members of the committee. I'm here to answer any questions you have at this time.
Commission members, you have no presentations, just available for questions?
Yeah, I think our site plan and our drawings were included. If anybody has any questions, basically, I'll just tell you real quick. We're hoping to be a music hall, right? We want to bring some live music to the Danbury area. We think that's lacking. The owner of the building is also my partner in the business. So we try to find a fit for that space that wasn't going to cause us to fight with the other restaurants for parking. We thought it would complement the other restaurants in the area. After dinner, maybe you could come out and see a band, or maybe eventually we'd like to do a comedy show or something like that. We really think there's nothing else in the area, in the community, like that, to see either a small band or a tribute band or whatever you have, other entertainment.
Thank you very much. Commission members, any questions of Mr. Commissioner Melillo?
Yeah, I apologize if you've said it and I missed it. Sometimes you don't quite hear everything over the Zoom.
Yeah.
Did you specify the hours that you're anticipating? My main interest is your anticipated peak time.
Well, we're anticipating opening after 8. Probably start out 4 days a week, and then if we can schedule some live entertainment or special events on the other days, we would. So, the way we look at it is those restaurants that are there. The gym is closed by 8, so that gives us a lot of the parking lot. The restaurants kind of die down towards the 9 o'clock time, so it gives us the rest of the parking.
Okay, thank you. That's why I was wondering, because while I don't eat at Mixed Prime that much, I do frequent Zen regularly. They're one of the fewer places that my daughter can actually get Chinese food at. And I've noticed a lot of times that the parking lot is kind of full around the key dinner time of
Yeah, you're right, it is.
family dinner time. And so, as Mr. Dodo noted, so I was wanting to but around 8 o'clock, I could see it being a little bit less. So that's I was just curious how your parking schematic was going to work. So just out of curiosity, do you have an alternative arrangement for some overflow, or do you think that's not going to be a problem?
Right now, I don't think it's going to be a problem.
Okay.
Thank you. Thank you, Commissioner Melillo and Mr. Campisi. Any commission members, any other questions of Mr. Dodo or Mr. Campisi at this time? Thank you. Anyone else wishing to speak in favor of this petition? Anyone else wishing to speak in favor of this petition? Anyone else wishing to speak in favor of this petition? Anyone wishing to speak in opposition to this petition? Is there anyone wishing to speak in opposition to this petition? Is there anyone wishing to speak in opposition to this petition? Mr. Dodo, any final comments? Mr. Campisi, any final comments?
No, I just appreciate the time. Thank you.
Absolutely, our pleasure. Mr. Dodo, you good?
No, I'm all set. I think I sort of went over everything, and you have the package. I'd be happy to go over the site plan, but it's basically what all of you see when you're out there. I do want to add one thing. This is an interior fit up only. There's no changes to the exterior of the building associated with this, other than obviously a sign.
Good point. By the way, Mr. Dodo, your presentation was right on. Very, very efficient, and that's why you don't have any questions. You answered them all. Thank
Mr.
you.
Haddad?
Yes, Commissioner Melillo.
Either from Mr. Dodo or from Ms. Calitro, and this is just a reminder for my purposes. Is this something that would fall under the entertainment license purview, or does it not because it's not in the city center district?
It's not in the city center district.
As I could never remember if the entertainment license was city center only, or if it spilled a little bit out further. So that's why I was just curious.
Yeah, you can have entertainment activities. You just don't need to sign the license unless you're in, I think it's in the DRZ.
Yeah, I knew you could have it because I know some other places out there do. I just never remembered whether their license fell into play.
Thank you. Ms. Calitro, you have any final comments? Anything?
No, just remind the commission of the general criteria in 3F2 of the zoning regulations, and also that the floor plan that was submitted be part of any approval with conditions for the special permit. The floor plan showed the area to be used for entertainment as well as the other spaces.
Got it. Great. Thank you. Commission members, take note of that. Future reference. That's it. We're good. Anybody want to make any motion to Mr. Commissioner Melillo? Was that you?
Yes, I'll make
There you go.
I'll make a motion to close the public hearing.
There's a motion, Commission members, by Commissioner Melillo to close the public hearing. Is there a second? Second by Commissioner Ray. Any discussion? All those in favor signify by saying aye.
Aye.
All those opposed? For the record, I don't see or hear any opposition, so this unanimously, this petition is closed.
Mr. Chairman.
Commissioner Melillo.
I would like to move this to item number 2 under old business for discussion and possible action.
Commission members, we have a motion by Commissioner Melillo to move petition 40-44 MPR LLC to public hearing was opened on August 9th and closed on August 9th. So number 2 under old business for discussion possible action. Is there a second? Second by Commissioner Coelho. Any discussion? All those in favor signify by saying aye.
Aye.
All those opposed? Not hearing or seeing any opposition, it's unanimously decided. There are no continuations of any public hearings this evening. We do have a matter under old business for discussion of possible action. It's number 2. It's a petition of 40-44 MPR LLC, property owner Robert Campisi, for a special permit for cafe liquor license for Revolution, 40 Mill Plain Road, E15110 in the CA80 zone. Public hearing was open on August 9th, 2022 and closed on August 9th, 2022. Commission members.
Mr. Haddad.
Commissioner Melillo.
I'd like to make a motion to approve this petition as the use is compatible with the uses in the neighborhood. It will not have a detrimental impact on the neighborhood. It meets the criteria set forth in our regulations. And I'd also like to note the floor plan was submitted and included special accommodations as Ms. Calitro specified regarding the floor plan, noting the entertainment area.
Thank you. Commission members.
I'll second it.
Motion made to approve with reasons, second by Commissioner Coelho. Any discussion?
I would just like to say that it's kind of nice to see some live music possibilities returning to Danbury. I know various people have commented in the past that that's one of the things that's been lacking of late. So it is nice to see some live music potential returning.
As long as none of us sing, that'll be good.
Don't worry about that. I won't be.
Ms. Calitro, was that second reason on the motions acceptable regarding the floor plan? That's how you wanted it?
Yeah, that's fine.
Perfect. Thank you. Any other discussion? A yes is yes, a no is no. Commissioner Melillo,
Yes.
Commissioner Coelho,
Yes.
Commissioner David.
Oh, yes, only there's line dancing too.
Commissioner Fay.
Yes.
Commissioner Hawley,
Yes.
Commissioner Hylinski,
Yes.
Commissioner Jowdy,
Yes.
Commissioner Rhea,
Yes.
and I will make it unanimously. Congratulations, good luck to you, good presentation.
Thank you.
Thank
Good
you,
night.
petitioners, and thank you, commission members. Commission members, we have no new business. We have no correspondence. Are there any other matters? Any other matters? Any other matters?
May I ask a question, Mr. Chairman?
Yes, and then I'll go on to for reference only. Go ahead.
Okay, I'll just, I kind of under other matters, and I'm just curious, as Mr. Gucker noted, somebody did show up to City Hall tonight, and I know there's been some concerns with some people logging on, not identifying themselves. I'm curious if there's any thoughts about us returning to in-person meetings.
I guess it's open for discussion between us. I don't know, Ms. Calitro, we're still under, how long has the governor said that these, is it still, it's obviously still ongoing, but do you know how far into the future?
No, it's just whenever there's no time limit on it. You can continue this way, you can go back for a big, what you might anticipate a big hearing, big meeting. If you just had, minor things and you wanted to do it via Zoom, you could do it.
Yeah.
There's just notice requirements, they're a little bit different, that's all.
Notice requirements are different. Yeah,
I'm just curious.
Commissioner Melillo, it's so convenient, especially when the agenda is tiny. We don't have to worry about bad weather or anything. But anyway, go ahead. What were you saying?
I mean, I'd hate to just do this solely for our convenience. We are elected officials. We do
Yep, I
represent the
understand.
city, and I feel we're the only elected body in the city of Danbury that is continuing to meet solely by Zoom. The council's in, the Board of Ed. Granted, they're on summer hiatus right now, but they're in. They've done public hearings. So I'm just curious as to what the thoughts were for the commission.
Got it. Yeah, I guess. What's our notice? When do we have to decide on if we're going to have an in-person meeting as it relates to notice? I mean, do we have to decide tonight on our next meeting, or do we have a
no?
week or
But I
so
mean, we have
before?
to post it. We have to post it at least 48 hours.
Oh, okay.
So it's the week before. It's like the Thursday before because we're not in on Friday. Versus, sometimes if we did a regular meeting, you wouldn't have to necessarily post it to Monday with 24 hours in advance. So.
Yeah, I think, Mr. Hatter, I think if we did an in-person, the agenda could be posted Monday, but we have to notice that we're going Zoom. The Zoom requirement is what triggers the 48-hour requirement.
Yeah, my question is, does the commission get a chance to see the agenda before we make a decision? Or no? Okay. Well, I mean,
Chairman, I'd like to say, Chairman.
I have a minute, Mr. Haddad.
Yes, Commissioner Coelho, go ahead.
So I can make the opposite argument to that and say, I think it could be just as convenient for the public to have the Zoom, because while we might have missed one person tonight, I think the ability becomes a lot easier for other people who may not have the means to get to City Hall or make arrangements to care for people in their family or kids and children to make these meetings. So I think it's more convenient for the public that we keep them in place. I'll meet in person if we have to, and it's fine with us, but I think it's easier for the public that they're set up this way. I think it's more convenient.
And Mr. Chairman, go ahead, Commissioner David. Let Milan speak first.
Okay, Commissioner, thank you, Commissioner Coelho. Commissioner David.
Yes, I mean, just like Mike says, I mean, it may be more convenient for other people to jump on, especially at 12 o'clock at night.
Yeah.
You know what I mean? Like people have to go to sleep you have to get up at 4:30 in the morning. Come on.
All right.
The only other thing I wanted to say, if you haven't been into the council chambers, they are reconfigured. So And the council operates kind of sort of a little different, than we do. So I would just say, go take a look if you're in City Hall. The dais is set up differently with how we would have to,
Yeah,
and
I know
people would have to
plan-
do presentations. I mean, that's what we obviously can do. Obviously, we'll do whatever the commission wants, but it isn't what you may have been used to in the past. That's all I'm saying.
Ms. Hylinski, your mic is off. Did you have something you were going to say? Oh, okay. What else, commission members? Anybody want any other comments on the subject matter? No, I guess if there's a strong opinion by any commission members prior to the next meeting, express it and we'll see where it goes from there. Thank you for that.
If I could just
conversation.
also, Mr. Chairman, just get one way or another, I can do a Zoom meeting for the next meeting, but I cannot do an in-person meeting.
Okay.
At the next meeting. So.
Well, then we'll do Zoom for the next meeting and then we'll see what happens then. For reference only, we have 3 petitions, Delaware MMP Realty, and I think we have a date change on that.
Yes, that's correct. We're going to push the public hearing until September 13th, which is still within 65 days within which to commence the opening per statutes at the request of the city, and they're still working on the agreements relative to that. So.
Thank you. The second one is Pioneer Realty, the Mercedes-Benz, that's still set for August 23rd, 2022. And Triangle Street, the Bridgeport Roman Catholic Diocese Corporation, that's still set for September 13th, 2022. So I'll ask again, any other matters? So I'd look, I think, if nobody has anything else to say, about motion to adjourn.
Motion to adjourn.
This is not a record breaker, but we're ready to close anyways. Motion made by Commissioner Rea to adjourn. Is there a second? Second by Mr. Jody. Any discussion? All those in favor signify by saying aye. All those opposed? Not hearing or seeing the opposition, let the record